We've got several individuals that will be coming in to testify today. I'd like to start by asking our Chair of Public Safety, Senator John Albers, if he would offer up a prayer for this morning.
Thank you, Mr. Chair, and please bow your heads. Lord, thank you for this day. Thank you for the sunshine. Thank you for this opportunity to come together to really do the people's work and to make sure that we're very thoughtful and compassionate as we come together to find solutions in order to protect the public here in Georgia. And Lord, we ask you just give us your grace and your constant discernment as we continue throughout these proceedings. For your most holy name, we make our prayer. Amen.
Amen. Thank you, Chairman. All right. I'm here today. We have, again, Senator John Albers, Senator Sonia Halpern, Senator Tim Bearden, and I appreciate the committee members here. I know Senator Strickland had a case in court this morning, so he was going to try to listen in. And as we move forward in our discussion over addressing the issues that we hear about at the Fulton County Jail, what we have discovered is the primary concern, I think, that we need to solve is the overcrowding issue there, which sometimes what we have found out, it begats a lot of the other problems. And in setting up this meeting, especially since the other meetings we've covered, we've had the Sheriff's Office come in, Fulton County Sheriff's Office come in and speak to how they operate the jail in a very broad sense. The particular issues that they have, given us data and number as far as the crimes, or excuse me, the individuals' charges of the individuals coming into the jail and how long they're staying. And surprisingly, since the committee started, Chairman Albers was able to pull some numbers up, and we looked at it, and it seems that people are moving a little faster now. And I hope it's because of the fact that outside they have discovered ways to solve the problem on their own. But I think this committee at the end will be able to offer up some solutions, of course, to help. We've also had the judiciary come in, had multiple individuals throughout the court system come in and testify as to the operations of the Fulton County Superior Courts, the clerk's office, and we've heard a lot of innovative ideas, a lot of really good ideas, and we've heard some concerns. And again, this is a process. It's if everybody goes through it and everybody's comfortable, then we're not doing our job, and that includes committee members. We've had the prosecuting attorney council come in and speak to the prosecution side. We've had the district attorney's office come in and speak to the prosecution side, so that everybody understands what the process is and see if we see any knots or delays in the process that are causing the overcrowding situation to reach a level where it shouldn't be, because let's be honest, most jails in Georgia are overcrowded to a certain extent. And so far everything has been very productive. Pulling these witnesses together, I want to thank Allison Bailey. Allison's done a great job reaching out and getting everybody together. We had a very positive response from everybody we reached out to once we were able to get in touch with them. We continue to find out that if we want to reach somebody outside of state government, it's very simple. If we want to reach somebody inside state government, it is not so simple. And that is a problem that I'm sure we'll solve in the future. But throughout my conversations with everybody seemed more than willing. But on a couple of occasions, people ask me, and I know Chairman Albers and I dealt with this at the beginning of this and other committees we've worked on, is they would say, well, what do you want to know? And I told them, well, are you asking me personally because I can't speak for the other senators on the committee? I said, but, we're trying to address a problem, and there'll be a multitude of questions. And I've had individuals tell me, well, I just want to make sure I don't upset elected person so-and-so, elect a person so-and-so, or elect a person so-and-so. Well, we inside this building represent 11 million Georgians. We represent the individuals that are pulling Kias off the assembly line this morning, those that work in our ports, those that are working our poultry plants, and those that work on our farms. And we owe it to them to ask the tough questions. And those that sit before us and who draw money from the taxpayers should be required to answer those questions. There are no winners and losers in this except the citizens. And it's our job to make sure that the citizens win. And so any witness that comes before us, if they're uncomfortable, if they feel that our questions are questions that will put them in a bad light with a friend or another elected official, then I cannot apologize for that. It's our job to get the answers if we're going to solve this problem. I think all of us took the oath, and I know the committee members sitting at this table are extremely serious state senators and are serious about their job and serious about their oath. And I'm thankful for that, and I'm thankful for Chairman Albers selecting these senators to serve on this committee. And with that being said, are there any senators with any questions or comments or concerns? Yes, sir, Chairman. What mic are you on?
Number 9.
Okay.
Thank you, Chairman Robertson. I first off really appreciate the fact of your background and the thoughtful approach you have taken throughout the time in this committee since we started it last fall. We have heard a lot of great testimony. I couldn't agree or echo your comments any better than the way that you had described it. And what I look forward to is when we are concluded, and obviously we've got several committee meetings to come, putting forth some really good recommendations in order to fix the problem, because that's what we want to do, right? Ultimately, we have to solve the issue that's in front of us, and that's our job as lawmakers and to provide oversight. So thank you for the great work that you did, and I'll look forward to hearing from some more experts today.
Thank you, Chairman. And I do want to point out that in the upcoming meetings, and as I was putting the last few meetings together, I spoke to Chairman Albers again, and we talked about days. We didn't talk about mornings. We didn't talk about afternoons. We talked about days. So there's the opportunity. These next 2 meetings that we have on the books could be 6 to 8 hour meetings. One of the meetings will be with the Fulton County commissioners, and we'll be discussing the budgets for the Fulton County Sheriff's Office, the Fulton County District Attorney's Office, and the monies allocated for the judiciary within Fulton County, to include the public defenders, which in many cases are kind of left out of the conversation, and something that we have worked on in the past. And then in the next meeting, which should be a long meeting, we're going to invite the public and any group who has any concerns with the operations and functions of the Fulton County Jail and the system around the Fulton County Jail. And I point that out, and I appreciate Chairman Albers' reflection back on my career. And I think what we remembered from our very first meeting is the criminal justice system is much, much more than a county jail. A county jail is a holding area for individuals who have been introduced into the criminal justice system. The responsibility of moving bodies back and forth, human beings, citizens back and forth out of the county jail, rests with the district attorney's office, the public defender's office, and the judiciary, and any other programs that they may have, whether it's an accountability court or whatever. We put a great deal of responsibility on all of these individuals. So as we go through this process, we need to remember we're looking at multiple gears and levers and not a single piece of the machine. So with that said, we will get started with a group who was not hard to get in touch with and who has always been receptive to conversations and coming down and visiting with us. And speaking on behalf of the Cobb Judicial Circuit will be Judge Robert D. Leonard. And Judge, if you want to come up and grab microphone 2 there in the middle.
Sure.
And Judge, basically we want to understand the process by which judicial circuits who say they are short-staffed judges, exactly what the process is for them to apply,
Sure.
to expand their circuit, situations that y'all run into during this problem, because I do know that there have been, to put it kindly, differences of opinions as to caseloads. And even though we're focusing on individuals in jail, we understand that there are individuals out on bond and in other situations awaiting court. And what I'd really love to focus on, And we have to discuss the civil side to some degree because it does have an impact on how efficient the judiciary operates. But if you would basically give us the 101 version of exactly how these judges or how these circuits are expanded as far as judge numbers and things of that nature.
Yes, Chairman, certainly. Thank you for the opportunity to be here. My name is Rob Leonard.
Did you pull that a little closer there for you?
Is it on? All right, good. So my name's Rob Leonard. I am a judge in Cobb County. I preside over our Veterans Accountability and Treatment Court. But for your purposes here, probably the most important thing that I do is that I am the chairman of Judicial Workload Assessment, which is a standing committee of the Judicial Council. I will start by kind of giving you the 30,000-foot view of what we do and how we do it. Our committee, it's a working committee, and what we do is we come up with a formula, and that formula is derived from case counts. So as you know, the clerks of court, they submit their case counts into the AOC. We put those into a formula. The formula, the most important part about that is that it represents a statewide average. And so we engage in what's known as a time and motion study, and we have the assistance of the National Center for State Courts when we do this. And it's kind of like a throwback to the days where back in private practice where you would track your time. So all the judges track their time. What kind of cases were you working on? How long did you work? And so we do that over the period of a month, and it's extrapolated out. And so we know that the average time for a serious violent felony is this, and the average time for a divorce is that. And so once all of those are come up with, those case counts come in, they get assigned to that minute value per case. When it comes to criminal cases, you count per defendant, okay? Civil cases, you count per case. And so that formula yields what we call a judicial workload value. And at the point that you receive a 1.2, 1.0 being like, okay, we're pretty much where we're at. A 1.2, we're overworked by 20% or so. It's time for a new judge. And so anybody that's a 1.2 that gets that number, they apply through the committee for a evaluation of their circuit's workload. The numbers get looked at a little bit closer. You get the final value. It goes to committee, and the committee will typically vote to approve everybody that comes in above that 1.2. And we hear from the chief judges of those circuits what's going on. We send that on to the Judicial Council. Judicial Council will approve it and then forward those on to you all here, the policymakers and our partners in the General Assembly, to look at what do we do. Right now, there are 6 circuits that are still qualified for new judges. And if you're interested in what those are, I can tell you.
I would be, please.
Sure. So this year's case count has not been finished yet, but from last year, the circuits that still qualify, as you know, Tifton and Houston both received their judges last time, so they're now off the list. Douglas did not, but was budgeted for, and so they're still on the list. Clayton County, their 3-year recommendation expired. I expect that they're going to reapply. So the others that are still on the list: Stone Mountain, Augusta, Northern, Tallapoosa, and Alapaha. So those are the 6 that are still qualified.
And with that said, Judge, with the exception of Clayton, could we say those aren't metro circuits, right?
Well, Stone Mountain is metro.
Right, because Stone Mountain would be a part of DeKalb.
DeKalb. It's DeKalb.
Yes, sir. Okay.
Yeah, it's a single county circuit.
Right.
That's DeKalb.
And I think the Stone Mountain Circuit the one we renamed?
I think they renamed.
Yeah.
So that
Correct.
would be now the DeKalb.
They're going to be the
Yeah.
DeKalb Judicial Circuit. next time,
Right,
yes.
okay. So that's the only metro circuit
Correct.
that's really in there right now.
Correct.
And I'm sure, like you said, Clayton may reapply.
Correct.
And so to understand, simple terms, any judicial circuit that gets 20% above their capacity
Correct.
can apply. But the 20% initially, they are saying they're 20% using the formula, and then you guys kind of look at it and make sure that everything's lined up correctly?
Sort of. So the clerk of court, they report all the data to the AOC, and then there is a preliminary report that's made by adding up all of those cases, assigning the minute value, going through the formula, and it will yield that number. And so, I know we're talking about the Atlanta circuit here, from what from your opening remarks, they were a 1.17, very close. So you get that preliminary number, and once you say, the chief judge makes a call, we're either going to apply or we're not going to apply. And there might be reasons to do it, reasons not to do it that exist locally there. So not everybody that comes in at a 1.2 will actually apply. Most
Okay.
will, but not everybody.
Chairman Albers, real quick.
Yes.
Judge Leonard, first, thank you for your great service. It's an honor to represent a good chunk of Cobb County, so we appreciate you and your team.
Yes, sir.
So at the Atlanta circuit being a 1.17, do you have to hit that 1.2 threshold in order to ask for an additional judge?
That, the chief judge could submit a request to us. I'll tell you what happened in Atlanta this last time. There was, you may have been involved in some conversations early on. Their initial number came in a little higher. We had to go back and look at those numbers. There was some accountability court data that was missing. Added the accountability court data, and then discovered that there had been a misassignment of a category of cases into the wrong box on the spreadsheet. Fixed that, and they actually went down from the 1.22 to the 1.17. I thought Judge Glanville was going to get me down at the conference, but he was a true gentleman about it. Said, look, this is what happened, and he said, well, I don't feel good about asking for the judge if we're coming
Okay, so
in
he
at
did not
1.17.
ask,
So
okay.
they pulled their request, and even though they were planning to.
One further question, if I could.
Yes.
One of the conversations we had when we had Judge Glanville and McBurney here was complexity of cases. With Fulton obviously being our capital county and probably our largest, clearly our largest business center, and which attracts all sorts of goodness and other challenges.
Sure.
Do we, believe there could be a higher level complexity here in some of the closer metros and other areas, and if so, do we account for that?
So let me say this. There's a difference of opinion around the state. And if you ask judges that work in the metro, there is a feeling about the complexity of cases. I can tell you, I feel like I'm married to a divorce lawyer, so I'm not talking bad about him, okay? I feel like the domestic bar, for one, is more litigious in the metro area. There may be other circumstances on the ground down in Vidalia that don't exist in my circuit, and I don't really know what those are. What we deal with is a statewide average, as I said at the start. I think your regular civil cases, even though there may be more, you sue the state, you sue an agency, it's got to happen in Fulton, right? So those cases all do come here. I don't know, I don't know what the argument would be to say that the formula doesn't correctly allocate for those. I'm sure that some of them are more complicated than others. What the formula will never be able to account for are the one-offs, the anomaly kind of cases that there isn't any way to really plan for. For example, what Judge Glanville is dealing with right now with that YSL case. 600 and however many minutes you get assigned for a serious violent felony. Well, he crossed that threshold 40-something weeks ago. That's a different kind of animal. And so I would tell the committee that it is really hard to plan for that. Judges, we deal with what you bring us. We don't plan for it. That's really a product of the district attorney's office. And if you bring a broad sweeping indictment with 20 defendants and it's going to take 2 years to deal with, well, there's 2 years of my time gone. And there isn't anything to plan for. There isn't a big enough sampling of data that you could work something like that into this.
So I guess one final question, if I could, and maybe this is a takeaway, even a request. It would be great if and we don't know the answer to this, so that's why we're asking you, if we could determine if, because Fulton's unique and because, again, anything filed against the state happens here, if there is a reason to add something to that for the complexity for what happens here being the capital county for the circuit, et cetera, in Atlanta, we would ask that you would take a look at that and give us a thumbs up or a thumbs down. You may say, no, we looked at this and it doesn't make any difference. Or you may come back and say, actually, after some consideration, maybe it does. That would be very helpful to us as a committee because we're trying to be very thoughtful about this. And, I like to take emotion out of everything and make it a mathematical equation. But to make a mathematical equation work, you have to have all the right numbers there.
Sure.
Thank you, Your Honor.
And Judge,
Yes.
when we talk about the complexity, when we're talking about a murder case, unless it's a capital case, which is an entirely different animal, and we don't see many of those in Georgia anymore, a murder case in the Atlanta circuit and a Fulton case in a murder case in a much smaller circuit still has the basic requirements. Everything from indictment, voir dire, all the way through the process. So we're dealing with apples and apples. Would you say that probably the most complex issue that we have, and I think rightly so, would be that Fulton is the court of filing if there is an action against the state or someone attempts to take an action against the state?
I would say that is one thing that makes, the Atlanta circuit unique. I wouldn't be comfortable assigning any number to it, right? To say, oh, well, they should get a bump of this number or that number. It's hard to say because, as I said, we're dealing with statewide averages, and so if there's a taking, an unlawful taking case, it gets, or something like that, dealing with DOT, a lot of those cases, are they going to go to hearings? Are they going to settle? All of that stuff in theory is baked into the formula. The judges in Fulton participated in the time and motion study. I am sure that, if something like the YSL case were going on at the time that the time and motion study were done, it might have weighed a little heavier on those serious violent felony
Right.
cases.
And the YSL case,
Yes.
multiple defendants,
Yes.
cases going on, single judge, multiple attorneys. I'm sure there's a district attorney prosecution team there.
Right.
In your experience, if you factor that into the formula, and that's a very unique case, don't we skew the formula moving forward because there's not a YSL case every 2 years?
Correct. I'd be hesitate to try to bake something like that into the formula. My point was, if that had been going on, that would have been one judge, 100% of their time devoted to
Right.
serious violent
No, and I
felonies when we
understand
did the
that.
time
What I was saying was when Chairman Albers brought up the fact that numbers matter, every once in a while we can have that anomaly.
Right.
That if we allow it to, it can bend it can bend to the right or bend to the left in making those decisions. And remind us how many judicial circuits there are in the state?
50, I think.
50.
51?
51?
51.
Oh, yeah.
Yeah.
Yeah, that's right.
Okay.
Yeah. And thank you. Of the ones that you've dealt with, have you ever ran into an issue where there is a judge on the bench in Superior Court that does not carry a docket?
I can't recall that. And you got to keep in mind, we deal with circuits as a whole rather
Right.
than individual judges. So yeah, I just
And that was just inexperience, and my experience in Superior Court is usually standing
Yes.
in front of a judge or sitting in a witness box. But it just seemed unique. And if we have 20 judges and our numbers are here, then the simple math would be 20 divided by the number of cases to step into the door to say, in a perfect world, each judge would be able to handle this many cases. But if we have 20 and 19 are hearing cases and we put the number in, then we have a skewed number if we use the number 20. Because the load is being carried by 19
Correct.
and not the full 20. So I just wanted to be clear. And again, we receive a lot of information, and it's something worth looking into.
If it's a chief judge issue
Right.
that you're referring to, Chairman, I
Right.
will tell you, having been the chief in my circuit, it's a heavy workload.
And I
It's a
appreciate
heavy
that.
workload.
Yeah,
And I'm sure if I had
Gil
20
McBride
Yes, sir.
and Art Smith, and I've worked with some chief judges, and I know that that their responsibility goes beyond the bench
It does.
in some of those cases. But thank you, Judge. Yeah.
Mr. Chair, I'm going to follow up on the chairman's line of questioning. For those elected judges that are in any circuit, they're obviously elected by the people. Is it the job of the chief to manage their workload and make sure that they are carrying their load and their weight and hearing as many cases as their peers?
Is it the job of the chief to deal with their own caseload?
Well, no, for
Or
the others.
All right. So I will tell you this. The public at large thinks that. They think you get the title of chief, you're overseeing the whole thing, and they want to write you letters. Oh, this happened to me in front of Judge so-and-so, and that happened to me in front of Judge so-and-so, or this judge is doing that. You know, look, we're not, the chief judges are not the JQC, all right? We don't have the ability to control the other judges. If Judge Glanville's got 19 judges, he's got 19 independent, constitutionally elected officers that each can do whatever it is essentially that they want to do. He would like to, as the strong leader that he is, be able to, you know, corral and make sure everybody's paddling in the same direction. If everybody got on board with that, they would be paddling very efficiently in that same direction. I don't know what goes on in Judge Glanville's chambers or what goes on in the Fulton County bench as a whole. But I would assume that they get along well and all paddle in the same direction.
Chairman Albers and I on the majority whip team, and we understand the complexity of getting everybody to row in the same direction.
Yes, sir.
It is very difficult. If I could have one further question. One of the things that we have seen and analyzed, and I'm sure this is not specific just to the Atlanta Circuit, but we have some judges that are working extraordinarily well, doing night court, doing Saturday court, doing all sorts of things. And then we have some where we've got badge stripes in and out of the building that don't equal double digits in a week of work. So what I think I'm hearing you tell us and me understanding is that they are only accountable to the people who've elected to them, and perhaps some sunshine on that would help.
And that does not factor in to y'all's decision, because those, you know, you're given the basic numbers and to do the simple math, and then to make the tough decisions to tell some of your peers, hey, you haven't reached the threshold yet, you just think you're overworked. When in fact they may be, but you may have another circuit that is a 1.3 or whatever, and it's something that really needs to be addressed. And what I've seen in the past is Fulton County Atlanta Circuit has stayed out of the top 10 or at least in the lower part of it, where other circuits have had to have serious issue or have had serious issues, and they've been addressed by expansion of the bench. Would that be fair to say?
I mean, it's fair. I think, you know, look, I can't speak to the issue that you brought up, Senator Albers. I will tell you from the judges that I deal with and the judges I've been around the state and talked to, I mean, what I see is a hard-working group of men and women that are public servants that do a good job for their local communities, that take their jobs very seriously, take their oath seriously, as you mentioned at the outset, Chairman. And so I don't think that would be a widespread thing you would see around this state. You will certainly have circuits come in and, you know, the Atlanta Circuit has said, well, we've got, you know, there are so many judges, it takes such a huge number of cases to move our number even a little. That is true, because it's an average. And whereas, you know, with a two-judge circuit going to 3, you know, a smaller number of increased, you know, serious violent felonies would move them over that threshold. So, look, my message to everybody here is, you know, when you show up on that list, at that point in time, you need a judge.
But you said something early on, in that the courts are somewhat, and you know, my choice of words aren't always the the best in these situations. But basically, the court system is held hostage by the process, by the district attorney's office as to for the case, because you don't get to you don't walk in there and pick out all the cases you want and say I'm taking all these. Now, do you find that most circuits judges carry, like some judges will be running a criminal docket for 3 months while others run civil dockets, so that, domestic, so that your wife's cases are being heard along with the gang cases and everything else on the other side? Or do you notice that it's more of a mixed basket where the judge may be hearing a criminal case for 3 days and then jump off onto a civil case for 2 days, and then the following week he's doing family law or domestic?
Most of our dockets, most of the judges around the state typically are dealing with everything from A to Z. As you know, we're a court of general jurisdiction. We deal with it all. And so usually you don't see a whole lot of dividing up of civil versus criminal. Now, I know in the Atlanta circuit they've had to get creative in how they move things. They've got the family division, which is the program where, and I think a lot of that is driven by there's so many self-represented litigant filings that go through that, that process in the domestic arena. And so, some places have had to get creative, as they can do, to try to come up with a more efficient way to skin the cat, so to speak.
And I think one part of that creativity that has been incredibly successful is the court that you are dealing with, that you have jurisdiction over right now, which is Veterans Court.
Yes, sir.
And
It's my favorite thing I
my
do.
former job, we opened up a veterans dorm in the jail early on,
Yes.
and we had a lot of success. Thank goodness with Fort Benning/Moore there.
Yes.
We were dealing with a lot of veterans who were finding themselves involved in the criminal justice system, and the use of veterans courts and other kind of accountability courts. Not only have they assisted the individuals that found themselves detained in the county jail, but they also allowed the courts to move more efficiently, so these individuals wouldn't, for lack of a better term, clog up the system.
Sure.
And so I really appreciate what you're doing there.
Yes, sir.
Okay, and once you get past the 1.2 and you do your list, and it goes through the, I think you said the Judicial Council, they
Correct.
approve your recommendations.
Correct. Judicial Council will then, if they approve the same recommendations that come out of committee, they will get listed typically in the order of judicial workload value, going from highest to the lowest of everyone that qualified and was approved. We would forward that list on to the General Assembly. And then from there, it's a policy-making decision with you guys, how many.
Is there an appellate, is there an appellate process where if they feel they didn't end up where they thought they should have ended up, where they could come back and challenge?
You can appeal in committee. Frankly, we've not had that happen. You can appeal in committee if you think there was something wrong. And we do allow for, amendments, and we encourage them. So we say, for example, judges, we want you to comb through these numbers that the clerk has sent us. If you see things that look out of whack, so for example, I've seen circuits that had no probation revocations. All right, I know that's not right. I know for certain it's not right. And we would have a staff member call chief judge, call the clerk. Hey, looks like maybe there was an issue here with your probation revocations. We all know that, your probationers down here aren't that much better than mine, that we don't have any revocations, right? So when we see anomalies like that, we will point them out and encourage them to make those corrections, go in, take a look at their data. Some of it, Chairman, frankly, you've got constitutionally elected clerks in all of these different judicial circuits, and a lot of them use different sorts of case management systems. And so it's a little bit of some of them have got technology issues, some of them, are newer and maybe not as experienced. And so the judges themselves cannot, get all that data or manipulate that data. It is in the hands of the clerk.
I guess the thing that frustrates me the most as a law enforcement officer is I can go to any law enforcement agency and pick up a policy manual. And in most cases, they're going to be the same. Whether it's use of force policy, whether it's off-duty behavior policy, all of this stuff pretty much tracks along because there's such a tight system set up. If a police department does not, I had an individual, I went and had to speak to a council one time. There's a very small police department. I asked him to see his policy and procedure manual. He said, I'm a new chief, haven't gotten one yet. I told him, go to the International Association of Chiefs of Police, get you a model policy. I know Senator Bearden knows what I'm talking about. I said, and make it applicable to your agency. It was a 5-day fix. Took it to the mayor and council, and you got it approved. It's fairly simple. And so I find it frustrating as we have gone through this process that we don't see uniformity. And, you know, and I love this phrase, and you use it, and I know why you use it, and I appreciate that fact. I've heard sheriffs use it and everybody else. I'm a constitutionally, you know, and all this other good stuff. Well, you know, that and $2 will get you a cup of coffee. Sure. Because it seems like that everybody forgets who their boss is once they become a constitutionally elected officer. And it's not me, and it's not Chairman Albers or Senator Payne, but it's the men and women who stand before them in the courtroom. It's the man or woman who are standing at the glass in the clerk's office attempting to get some resolution with a problem. And it's every crime victim in this state. And so it may not happen for as long as I'm in the Senate, but at some point there has to be continuity throughout the criminal justice system, from Savannah to Columbus and from north to south. And I know that's not your committee's responsibility, but what I do see is I do see continuity in your process to where the 1.2 is there and somebody can come back and try to leverage, and I don't mean anything unethical, but try to really push the point. And I love the fact that y'all have a hard number that you've set as a standard. And whether it's the largest circuit in the state or the smallest circuit in the state, everybody is held to the same standard. Right. And I just wish it would be nice if your staff did not have to call, because I think it's very simple to understand a revocation. And those occur everywhere because human beings are going to violate their probation. A certain number. But in that case, if somebody wants to run and have that job, then they should know how to do the job. And fair or not fair, our system doesn't take that into accountability, you know. So I find it frustrating that we go to different circuits and we find different case management systems. We find different jail management systems, and I can't imagine attorneys going from circuit to circuit having to deal with an entirely different set of rules every time they try a case, you know, outside of town. So it sounds difficult. Go ahead, Judge. Apologize.
Y'all could, you know, it would be, you know, look, at the risk of, you know, getting Mike Holloman upset at me, you know, you can turn court records over to courts, right? If you said, all right, judges can appoint a clerk, and you would end up with clerks that were qualified. And a lot of our clerks around the state are very well qualified and are great public servants and do a good job. There are some that aren't. And, you know, for the judges, we share your frustration. There are judges all around this state who call me up at case count time. You know, I've got all these open cases. I can't get my clerk to close cases. You know, and this is arguably one of the most powerful people in the county who can't get his clerk to close cases. And so, yeah, your frustration is not unique to the chair that you're sitting in.
And tell me the impact it has on the 1.2, or does it have an impact on the 1.2 of an open case and a closed case?
No, that would only impact you know, clearance rates, disposition,
right.
closing.
Okay.
Yeah.
Well, and clearance rate is a factor that goes into the formula?
Clearance rate is something different. So what goes into the formula, we deal with new filings. You know, so we're going with a 3-year average, new filings with the minute values that I told you about in the formula. The closing of cases over time is a different deal. So it goes new filings is what the workload, the current workload is based on that.
If a judge is still handling the case, then that case was there to begin with. So
yeah.
in the
keep in mind, we're still trying to close the 2021 cases as we're getting the 23 and 24s in. Yeah.
Very good. What numbers?
I'm going back because you mentioned something and you were in a line of questioning that I was going to have. So just a follow-up on the question around judges and how they use their time and how that tracks. So you said the chief judge really does not oversee the judges. They have a title that would make you assume that. But in fact, each judge gets to run their own docket, their own office the way they want. So where is the responsibility? I know that the clerks are going to input the information, and you're going to see and create this statewide study on time.
Mm-hmm.
Who would be responsible for tracking the work of each judge? I know that we said ultimately the judges really, report back to the people who elect them, but in fact, who keeps track of? Is there anybody in the process that actually keeps track of the judge's workload? And do you ever look at it kind of county by county? I know you're really looking for that big, broad statewide view, but do you look county by county, and is there value in doing that? And if there is, who is already doing that?
I don't know where and what circuits might break it down judge by judge. If you're asking judge by judge, I think that would be something that would be unique to that judicial circuit. What we get are the totals for each judicial circuit. So I don't know what this judge does versus that judge. Our committee, it's outside the scope of what our committee does. Yeah.
So to go a little deeper on that, in the case where you had 5 judges, you would look at the total number of cases dispersed between the 5 judges. Right. You would not look at Judge 1, 2, 3, 4, and 5 and see who was carrying the heavier caseload.
Exactly.
Okay.
Right.
That's a great question.
Could be a good follow-up for us to request from the Atlanta Circuit, breakdown by judge.
And I don't know if there would be any value in your committee looking at that, other than out of curiosity to try to get a better understanding. I'm a research nerd, and I think the numbers do solve a lot of the problems a lot of times if we look at it. Because to Chairman Albert's earlier point, if despite what people believe, law enforcement agencies in the morning are not given quotas to go out and write so many tickets every day. And judges are certainly not, given, you got to move these cases through, because due process is an extremely fragile piece of art that can't be rushed. But if the judge is not on the bench to hear the case, then justice is being taken away from someone. And so, and look, and the reality is we have found lazy people in every profession. And so, but that's something I think that is worth looking at as we move forward. Go ahead, Judge. I apologize.
There would be limited value to us. We look at the circuit as a whole, all of the cases coming in. The case management systems, as they assign new cases to judges, would not consider how many open cases this judge had. So to your hypothetical, if there was a judge that wasn't working as hard as another judge, right, and they had a bigger open docket, it would not impact the number of new filings get assigned to that judge. So there should be, in my circuit, 1 out of every 11 is landing on my desk, regardless of what I did last week or the week before.
And to the point, it wouldn't have anything to do with the 1.2. It would strictly, like I said, as the research geek, is you're just curious about what the thing is. But if you look at that, you look at the judge handling the gang case here in Atlanta. I haven't seen his docket, but I'm guessing there's 1 case on it. With what you're hearing, with voir dire taking almost a year and then starting to walk into the case. So if you did look at that, you'd go, well, hey, we just got this 1 judge. If you're looking at it on paper, he's dealing with 1 case. But then if you look at the complexity of the case, you can understand why, he's certainly doing his job. And so, that would skew easily if you try to.
I bet you there's more than 1.
Oh, no, I agree with that. There's a lot of times in between there, and there's a lot of conference room cases going on too, I'm sure. But so there are those unique circumstances, and as everybody knows, there are some counties that they have grand juries all the time, sworn and working, and then there are some that they have grand juries every 3 months, 6 months, and I think possibly some that have them less frequent. So you don't see as many cases moving through there as possible.
Yeah, sir. We were running 2 in Cobb County during COVID.
Yeah. And,
simultaneously.
yeah. And so, you got some cases, like you said, 6 months easily. Anything else, Judge, is according to the process, and then it comes up to us, and then a senator or a House member carries that legislation.
Correct.
And we were able to do, I know we did a circuit split last session dealing with Coweta County and
Yes.
over there. But for the most part, once you make your recommendation, the list comes up here, then it's up to the legislature.
Policy-making decision, we respect, the General Assembly's, autonomy to do.
Which the General Assembly can look at it and go, no, we're not going to do it right now,
That's
and
right.
push it aside, correct?
The General Assembly can also say, we're going to fund all 6.
Exactly.
So-
Which would help you guys out a lot, wouldn't it? Yeah. Okay. Welcome, Senator Payne. We know it takes a while to get from all that carpet done and get this way, so we appreciate you. Anybody else have any questions for Judge Leonard? Okay, Judge, thank you so much.
All
We
right, my
appreciate your
pleasure.
time.
Number 6.
Yes, sir, go ahead.
I and my counterpart for Veterans Committees in the House was at a meeting this morning at 8 o'clock, so that's where I came from. I was still serving, even though
Just a
that,
little more efficiency would be greatly appreciated.
I didn't schedule that meeting either.
All right, we will keep moving forward. Ollie, Georgia Public Defenders Council? Yes. Yes, sir. We'll give y'all a chance to get set up. Chairman Albert steps out for a second. Yeah, she's on a scooter. Give Senator Albers a few minutes to make it back since he's got his injury, but basically this is a very simple and welcome good morning. I don't think I've seen some of y'all since appropriations hearings, but basically what we are asking, if you would, is educate the committee on the process of someone being held in one of our county jails and obtaining a public defender, and what a public defender's responsibilities are of moving that case forward for that individual from introduction to disposition, and any responsibilities beyond that. Public Defender's Office has always been something that I've thought is very important, and many times left out of the conversation when we talk about parts of our judicial system, because most taxpayers, most voters, most Georgia citizens get their judicial education on some TV show where everybody goes out and hires this big high-dollar attorney and brings them in, and they Perry Mason the case through, where they don't. And I would love for you to mention, if you have the ability to, the percentage of cases out of the individuals being held in some of our detention centers and jails around the state. If you have the solid numbers, or if you just want to say what you believe to be true based on your life experience in this job, would be greatly beneficial for the committee. So with that, if y'all would like to start, I would appreciate it. And your mic is on and your mic is hot. Yes, ma'am.
Under 50, Perry Mason.
Yeah.
It's a TV show.
Under 50 Perry Mason's a TV show, yeah.
Good morning. Good morning. My name is Amataya Ali, and I am the Executive Director for the State of Georgia Public Defenders. Just a brief introduction, and I'll let my colleagues here introduce themselves because I don't want to miss any important fact. I have been in the public defender world for 30 years. I actually spent 30 years in Fulton County. I always say that I grew up in Fulton County, and now I'm with the state almost over 4 years. In Fulton County, I was in the public defenders for 17 years, child attorneys for 2 years, and then as a CAO for juvenile court for 11 years. So everything I've done is in this arena. And I just want to thank you all for putting this together. Fulton County is the biggest, without a doubt. And whatever you do today, tomorrow, whatever comes out of this is going to be the yardstick by which we measure what should be effective, not only in Fulton County, but statewide. So I want to say thank you. In 30 years, I have not seen this. So I'm happy to be seeing this because we're going somewhere. We are the public defenders, and proudly so, and we represent all indigent citizens who cannot afford an attorney who have come to us. There is a misconception out there that if you're indigent, you belong to the public defender. No, if you want us, we want you, and we represent everyone who's filed an application with us and who said, I want you to represent. We start that for all the way from probable cause preliminary hearing, bond hearings, being in jail, on bond, not on bond, demand for speedy trial, all the motions that we need to file. We start from start to finish. And we make sure that our goal and our mission is to resolve the case as promptly as possible. So we can return the citizens back to their communities if that's what is deemed appropriate, or unfortunately sometimes if they have to go forward. But as the executive director of this agency now and having been in juvenile court for a long time, I know we have to go above and beyond the call of duty to make sure that those people who come out of our hands at the end of the day when they leave the criminal justice system, that we do something for them to make sure that they get the skills so they don't come back. We talk about recidivism, and I know that's something you're really, really aware of because of your background. Recidivism is just not going to go away until we make it go away. So when we say we start from the beginning to the end, we go above and beyond that call of duty. We now have programs sending our individuals who live in the criminal justice system to technical schools. We did a cohort in Atlanta, and that was 91% successful. We're in collaboration. We want to thank the Commissioner for Community Supervision, Commissioner Neal. He has been more than wonderful in working with us and making sure that the people that he provided those soft skills to, at the end of the day, then they come to us so that we don't return them. That's one of the solutions we're going to offer.
Madam, if I could touch on that real quick. You're
Yes,
talking
sir.
about this program within there, and you brought up the commissioner.
Yes, sir.
So these are programs that y'all can use as part of sentencing plea deals within the courts where you can say, we'll, based on the adjudication of the case, that this individual will go out into the community and go through some kind of training program if they're placed under community supervision as opposed to being incarcerated in the state prisons?
So we don't touch what community supervision is doing. They do a good job. They provide all of what you have just described. What we say to him is when you are done and they're done with probation and they are no longer under anyone's supervision, we like to take them and encourage them to go to school. So ours is voluntary and is being very well received
Yeah, is this a program that operates within the public defender's office?
within the state agency.
Which state agency?
Ours, the central agency.
Right.
For the state of Georgia.
And it's funded through the state?
No, sir. It's funded. We have, what we have done is that we have created a board, and we raise our own money to do that.
Okay, and so it's a 501c3?
Yes, sir.
Okay.
Yeah.
All
Well,
right.
we'd like for the state to fund it. Now, I'm not saying the state should not fund it.
Do you know how many people come before us and said we would like for the state to fund it?
Well, so I don't want to make it sound like, well, we don't want the state.
No, I
we're-
understand what you're saying.
We're very
Yeah.
happy for you
Yeah.
to fund it, but
Well,
in the meantime,
When you first said it, I thought that it was a part of community supervision, and because one thing that we are very conscious of up here is duplication of services.
Absolutely.
And so we tend to be careful when we see agencies agencies that are crossing, and we're duplicating the burden on the taxpayer, but this is a 501c3 set up separate, so it has no impact on the taxpayer.
No, and we
Right.
take the people that he is done with,
Right.
because at a point, he has to be done with some of the individuals because they've gone through probation. He provides soft skills, he does everything that he can possibly do, and then at the end of the day, they're done. What we say is, when they're done, then what?
Right.
What do you have at the end of your probation? They've given you soft skills, they sent you every program. We like for you now to go get a skill, a technical skill. That's
Very
where
good.
we come in with that program.
Perfect.
And at the end of the day today, before we leave, we have prepared a one-pager for you on what we consider to be solutions that we all can collaborate with other agencies to work on.
Did we get a one-pager from them?
Do we have it?
Have a one-pager?
Yes, sir.
Okay. Okay. Do you want to see what they have and pass it out to committee members, please?
Can you give it to me?
Thank you, madam. If you, yeah.
So our goal today, we'll answer all the questions, but we represent everyone. I listened to Mr. Skandalakis, and I saw that he went through the life of a case, what happens from probable cause to preliminary, and then the case is indicted, not indicted. We go for bond hearings. Those are all the stages that we are present for our client. Whatever it is necessary to do to make sure we can move the case forward as promptly as possible, and to make sure that we can provide effective assistance of counsel to our clients, that's what we do. And so I don't want to belabor this process by going through every stage what we do. But every stage in the book that is necessary, that's where we are. We file motions when we see that the case is going to trial. We file bond hearings when we see that they're not getting out, when we think they should get out. But when we think they should get out, it's based on a lot of factors. The judges have a lot of factors to consider. The district attorney has a lot of factors to consider. But we stay in the moment with our clients to make sure that we keep representing them.
And in simple terms, to your point about not repeating everything that
Yep.
Skandalakis, Mr. Skandalakis had to talk about, is a public defender is an attorney no different than any other paid attorney out there. You have the same education, you deal with the same type of clients if it's criminal, and they deal with criminal. And when it comes to your client's case being moved, and we're primarily focusing on those individuals who are in the Fulton County Jail, then the public defenders within Fulton County manage those cases, moving them through like any other attorney would, while at the same time having clients that may be out on bond
Absolutely.
or other things waiting to have their day in court also.
Absolutely.
The public defenders do not handle civil cases.
No, we do not.
And the public defenders do not handle the other kind of domestic cases.
No, we do not.
Public defenders don't do divorces.
No, we do not.
But, and so currently, how many public defenders do you have within Fulton County that deals with the numbers
Help me out.
of,
Good morning.
courts
I'm
and case?
Maurice Kenner, Circuit
pull it over there, please, Mr. Kenner.
Circuit Public Defender for the Atlanta Judicial Circuit.
Yes, sir.
Right now, we have approximately 127 attorneys within the Office of the Public Defender. Those attorneys handle cases in Superior Court, Juvenile Court, and State Court. But of course, our largest and most serious caseload are the cases that are maintained in Superior Court.
And what's the average caseload of the attorneys in Superior Court? Do you know?
That's kind of like a trick question. Okay, we have what we call the complex division and the non-complex division. The non-complex division handles cases, entry in autos, burglaries, and cases that are felonies, but not as serious as any of the 7 deadly sins. Those attorneys typically carry a caseload of from 175 to 250 cases. The attorneys that are in the complex division right now are carrying a caseload that's between 60 and 85 cases. But of course, those cases are much more complex. Those are the homicide cases, the rape cases, the gang cases, and they're just, they require a lot more time and a lot more investigation and a lot more resources.
Exactly. You can carry less caseload but spend more time on those fewer cases than you would if you had a higher caseload in the non-complex
Absolutely.
area.
Absolutely.
Perfect. Absolutely. What are you on, 6? I'm 8.
Just a quick question. So, because these caseloads are, I don't know, they seem high, heavy. So it makes me wonder, of the people that are coming through your office in Fulton County, of the number of people who need an attorney in Fulton County for any of these complex or non-complex issues, can you give us a sense of what percentage actually require public defenders versus who have the funds to actually hire attorneys themselves?
Well-
Like, are most of the people, in fact, coming through your office, or is it a pretty even balance?
I think I understand your question. In my opinion, if you're charged with a criminal offense, you need an attorney.
Agree.
Whether you're in state court, superior court, or juvenile court. Now, right now, my office, I think anecdotally represent probably 85 to 90% of the cases in Fulton County, and the remaining percentage are clients or individuals who elect to hire private attorneys or represent themselves.
Does that percentage, does it go back into the jail? Do you think it's 85% of individuals being held in the Fulton County Jail, or do you think that number's higher?
It's probably more like 93% in the jail.
Okay, and I want to be clear, the process I'm familiar with, when an individual fills out an application for filing for the application that I'm familiar with, which may have changed, they basically give all their financial information. And I want to be clear, indigent doesn't mean that you don't own anything. It just means that you don't have the liquidity of funds to where you can hire an attorney. You can actually own a house, and in some cases you can own vehicles, you can have a job and still not afford to hire an attorney based on the case, because and attorneys are expensive. Free world attorneys are expensive. And so when we say, if somebody sees somebody wearing a suit going to court, in some of these cases, these individuals are still indigent when it comes to the criminal justice system. And so it's not just the poorest of the poor, which they absolutely qualify. So, and I say that because I don't think people appreciate the high percentage of cases that qualify for a public defender. I think people think it's just a particular segment of society, but it's a much greater segment than they realize. And that the public defender's office is funded through the taxpayers. And so I just wanted to be clear on that, because when people hear indigent, sometimes they misunderstand what that means within the public defender arena. Yes, ma'am. All three of your mics are on. Yes, ma'am.
No, may I, and I promise to let everyone introduce themselves. And I just, please write that up to golden moments. Natalie, who is very, very relevant to this this meeting today because she came to us from after having been a CPD of a circuit in the state of Georgia. So I'll let her introduce herself, and she will take that next question after being a CPD. And the reason why I want us to take that question is the application process is a state application process, and so that applies to every circuit. And I know I hear what you're saying. What people hear from the outside would like to explain exactly
ma'am.
what it is that we do.
You can pull the mic over.
Sure. So I'm Natalie Glazier. I'm General Counsel for the Georgia Public Defender Council. Prior to this, I was the Circuit Public Defender for the Conestoga Judicial Circuit. So I'm familiar with how we do things in different parts of the state. I was an assistant public defender in Dublin, Georgia before that. So I've been a public defender my whole career, just in different parts of the state. And we all use the same application process. We do take into account if someone owns a car or a home or what's in their checking account, savings account. Our application process goes through looking at all of that, and then ultimately the determination is made based on kind of several factors. The main one is whether or not someone is earning a living below the poverty line, and so we use the yearly federal poverty guidelines for that, but we do take into account those other things on our application just to ensure that we don't have someone who is trying to take advantage of the taxpayers.
And that decision of approving a public defender or not rests with the Superior Court judge, correct? Or
No.
the judge?
It's with the Circuit Public Defender.
Okay, so the Circuit Public Defender goes there and determines whether that person qualifies or not?
We have an application process, and then it's the Circuit Public Defender. If somebody's on the line, they have the discretion of saying one way or the other, if it's debatable about whether they'd be indigent or not.
And is it not true that the individuals in the jail are offered that application to fill out early in the process?
Yes, and usually we have kind of two different determinations. We have an application right as soon as they are in jail, and then reassess it if there's a certain period of time after which they've been unable to make bond because maybe they've lost their job during that time. So initially we would have the application, but then if someone did not qualify, usually next time they're before court, the judge might ask us to take another application saying, hey, they've been in jail since their last court date, can you have them reapply?
But first hearing, they're asked by the judge, can they afford to hire an attorney? And if not, the judge will appoint one, and I'm assuming there are public defenders in the courtroom at the time, right?
That can happen where we represent someone prior to the application process at the judge's request.
Exactly. That's what I was trying to, because the application process is a process. It has to be checked out and, like you said, compared to certain factors federally and looking at the poverty levels, and in this case, so theoretically you could start in the beginning of representing somebody and then eventually they could hire somebody, but in other words, nobody's going to hearings without the opportunity to have an attorney, and in many cases that attorney would be a public defender, correct?
That's correct. And then if after that first appearance it's deemed that they would not qualify, we would not continue representing them.
Thank you. And the new system is working if anybody needs to hit their button for a question. Yeah. But go ahead. Yeah. Now, once you get them in the public defender, once you have the individual, then you move through the process.
Yes, sir.
Okay. So if, as we've heard in past, looking at jail overcrowding, the public defender's office is working exactly like any other attorney's working. And the determination of how quick cases move, in most cases, rests in the district attorney's office and in the judiciary. Would that be fair to say?
That is correct.
Yeah, okay. That you just because you're a public defender, you don't have a magic wand that expedites cases. And at the same time, you have cases where individuals are not incarcerated and they're still part of your caseload. Complex and non-complex, correct?
That's correct.
That is
Okay. And so if you did have a magic wand, what could be provided right now to the public defender's office that could or might help expedite cases while following the due process to make sure everybody gets their day in court, whether that is a jury trial or a plea or a null pros? What can be done to expedite that, to decrease the population in the Fulton County Jail, if anything?
So some of the magic one is already on that one page that we gave you. Our goal is to continue to work with the district attorneys all over the state to provide those rehabilitative resources that would allow our clients to transcend their current circumstances and be returned back to their city, to their communities. How do we do that? We're providing resources. We have social workers in most of our offices, and then we have them centrally located in the agency, and they can travel to wherever they're needed.
But ma'am, if I'm someone in jail with a complex case and I make bond, and you put an ankle monitor on me, I'm still part of your caseload, correct?
Yes,
I'm just not sitting in the Fulton County Jail.
yes.
But you still, I still fall in line with everybody else that you have to represent based on how swiftly my case moves from the DA's office to the judiciary, correct?
Absolutely.
Okay. Yes, sir.
Thank you, Mr. Chairman. Thank you for your testimony. Getting back to your one sheeter here, one of the things that we have learned throughout this process is that oftentimes once the calendar is set by the court, that things settle awfully quickly. Most people who are not involved in this have watched a lot of television shows and think that this happens in rapid fire, and then all of a sudden everybody is in front of a jury of their peers. But the reality is most cases never get that far. But once they're calendared, that's when everybody finally has to come to the table and usually figure out some type of a plea arrangement, et cetera. I didn't see that on your one sheeter, but I'm curious where that would rank as far as your thoughts.
So these are when the case is settled
Right.
and they're done. So I didn't put that because that's not contributing to the jail overcrowding of the population. The ones that we're focusing on are the ones who sit there, and that it's easy for the district because they have their own factors to consider. So we're looking for the ones who are sitting in jail who are contributing because they're there, their presence to the I don't want to say overcrowding, but the difficulty in being out of the jail. Those are the ones that we are considering here.
But wouldn't that be the same? I mean, if someone goes in and gets arrested and they get booked into the Rice Street facility, and they get a first appearance and they are not able to bond out by their own means, et cetera, and they're sitting there languishing in that jail, they're really waiting for their day in court, are they not?
They are. So my mistake. I thought you were saying once the case is played out or is resolved, we are not considering those. But
No,
you're
no,
talking about everybody who's sitting there.
By the time that the case is resolved, right, either they're going to go to the state prison system, or they're going to get put on some type of community supervision, or they're just going to be released and exonerated, or whatever their sentence happens to be. But the question is how do we get them through the jail process? The jail is not meant to be a permanent facility, right? That's why we have a prison system. And we've got some folks that Chairman Robertson and I realize have been there more than a decade. And that's just a travesty. Where we were looking at numbers from other areas of the country, and where I think in the Fulton jail we're averaging over 300 days, the average should have been closer to 30. So that's what we're trying to figure out is, the root cause of these issues. And we realize that public defenders can't force the trial calendar to be set, right? Or the prosecution to put things forward. But in your estimation and your professional opinion, is that not a big part of the challenge?
It is a big part of the challenge. It's probably the biggest part.
Okay.
But what we hope we can do is collaborate with our partners in the judicial system and put some social programs in. We're hoping to meet with the district attorney, meet with all the powers that be, to say there are some cases that we can work out by providing socially responsive resources to them, and they can be in programs outside of the jail, not in jail.
But the individuals that Chairman Albers is talking about are in jail.
They are in jail.
They're unable to get out. So are the social services offered as a part of a plea? And because we're talking about non-complex cases, let's say, because that's the largest caseload, we're talking about entering an auto. And in most cases, an entering an auto case that we see today are rare that it's entering an auto. Usually it's multiple counts of entering an auto because it seems like that these individuals are arrested eventually after they've done several cases. So are there tools within the public defender's office and the DA's office that can be used for an individual who's sitting in jail on multiple non-complex cases, to where you can say, hey, we want to fast track this through here, so here's what we've done. You know, John Smith, who's got these 8 entering and auto cases, if we plead out, if we do this for probation, whatever, is there an opportunity for us to move him to the head of the line, get him out of the Fulton County Jail, and get him back into society? And then, you know, the social stuff's out there, but our main thing is to get his body out of the Fulton County Jail. He's not able to post bond on those multiple non-complex cases, so he has to be expedited through the system. Is there a way to expedite those cases through, while at the same time not sacrificing the justice that every victim is allowed to have? Because this is not just about the individual who commits the crime. It's about the citizens who the crime has been committed against also. So is there a mechanism today where we can do that in Fulton County?
So I believe there is. Those are social programs all over the state and all over the city of
Okay.
Fulton County.
The social program is here in the end zone. How do we get to the end zone?
So that's why this one pager is all about that. We have to meet with the district attorney and say, these are the kind of cases that we believe are good enough to put them in a program outside.
Okay,
of
and
the
do we
jail.
do that today?
Our attorneys make those recommendations. The question is, I don't know how far those recommendations go. But
That's
after
a
this
great-
meeting
yeah.
today, how far are those recommendations going to go when we all come to the table?
Right.
That's what I'm hoping.
Do you meet with the district?
Attorney on a regular basis, weekly, monthly, quarterly?
When I was in the courtroom, we met just about every week
Okay.
on every case that's in the courtroom. And that has not been, I mean, it's been a long time ago, but I believe our attorneys are still doing that in the spirit of pretrial negotiations. How can we not try this case? How can we release this person? Bond hearings. And that's why they file their bond hearings every so many days. And we have those programs. The question is, how are we all going to get to the table now to make sure that we can consider the programs that are out here and use that as a pre-trial release alternative?
I think as a follow-up of your testimony today, which has been fantastic, is I think we were going to want to get some follow-up information to see how often are you all meeting? Is it happening regularly? Is it being tracked? How many cases is it helping to fast track or get adjudicated, et cetera? You know, in the answer to most problems is communication. And in the lack of that, things usually go sideways. So would love to get some follow-up information afterwards for the committee.
Absolutely.
So, because I kind of want to go back to the original way that you phrased the question. And I see all of these ideas here. And I'm wondering if the tug here is that because the cases have only been moving as quickly as they can, we have come up with programs and solutions and things that we can do given the realities of the situation today. But if you were given that magic wand, going back to that original question, are these still the answers to the problems today, or are there other solutions that you recognize today are causing the blockade in moving the cases? Like, that's the underlying question. What are the blockades that contribute to cases not moving? Whether it turns out that you offer programs and somebody says, okay, we agree to that, being able to move it, what's the clog in the drain that is not having the things move along, no matter what the solution might be, that if you had a magic wand, you would say, this is the thing that I would identify to shift?
So if I had a magic wand today, number one, let me just explain. There's been a backlog way before COVID.
That's right.
COVID only came to aggravate what we already had on the ground. And when COVID came, it brought attrition. It brought the great resignation, which we're still fighting. We, particularly in the Public Defender's Office, we want to be thankful to all of you. We have done very well with being able to get more funds for our attorneys. And that's because we were coming from a very low point, $45,000 for starting salary. You all have gotten us to a higher point.
Well, I do want to point out that
Yeah.
during the budget cuts prior to COVID, myself and Chairman Albers fought extremely hard that the judicial would not be cut because we anticipated the backlog, and the public defender's office was one of the primary areas we focused on because we understood the speedy trial issues and we understood due process, because we have the confidence in what y'all do and we both understood the case volume. So I appreciate you recognizing
No,
that. I do. Thank you.
You all have been very, very considerate. We need more, but.
Sure. That's what the last group came in and said.
But I have to say thank you firstly, because my 30 years getting to this point, to the state, it's been quite amazing working with the state legislators. Thank you. But if I had that magic wand, we will have more attorneys. We will have more money to retain our attorneys. We have done very well in this last 4 years, but we're still not competing with the outside world. If our attorneys, and I just tell you this very quickly, please indulge me. I had an attorney come to me and say, for the first time in my life, I don't have to wait tables. That's quite heart-wrenching, because these are attorneys. And not that we are important to wait tables, but if you have to do that just to support your income, how much time can you devote to your regional? So if I have that magic wand, we will be asking for more consideration. While we say thank you for the ones you have done for us, we will be asking to meet with the powers that be so we can implement more programs and more to identify the cases that they are going to be comfortable with. Lower level offenders should not be sitting in jail, but that's what I say. I don't know what other factors the prosecutors are looking into, because I see a threat by taking. I don't know whether that's the third one or that's all I see. I don't know what else they're looking at, so I can't take any credit away from them or from the judges who are looking at other factors in when they consider bond.
But the public defender representing that person knows what their criminal history is, correct?
They do.
Okay,
They
and
do.
the ADA knows what the criminal history is, so that could be the hangup. But to Senator Halpern's point, we give you more attorneys and give you more money,
Yes.
and so that the attorneys are well paid.
Yes.
But instead of everybody having 100 cases, everybody has 50 then. But there's still the same number of overall cases. So how do we get those cases moving? I remember there's a couple of people in the room that remember. I've got somebody I know well from the public defender's office. In our state court, there would be guilty plea, and you would go over to guilty pleas on a Thursday, and there'd be 300 people there who each had worked with a solicitor's office to work out a resolution. Some of those resolutions were dismissals. Some of those resolutions were fines and probation and all this. But we would move hundreds of cases in a day because of conversations between the Solicitor General's office and the public defenders who represented these state court individuals or paid attorneys who came in there with them. You would see in some of the most cases in the Solicitor General's office that concern me, but you would see DUI cases reduced to reckless driving cases with large fines, probation, license suspension, and the cases would move out so that would drop off the docket. Is there not a mechanism for these non-complex cases where we could do something similar to that within the Superior Court?
Typically in state court, like you said, those cases are not as difficult to work out. And in state court, those cases move relatively fast.
No, I understand. But when we say difficult to work out, to Chairman Albert's point that he said earlier, difficult to work out is communication. If it's a break-in of a vehicle, if there's restitution involved, then that could get a little complex. But bringing Randy Robertson in for breaking into 10 vehicles, if I come in there and y'all say, well, Randy, here's what we're going to do to get your case expedited, and you're going to end up on 5 years of probation, and you're going to have to report, then what we're asking you to do is plead to 5, 7, or all 10 of these cases. And I have the option through my public defender to say, no, I'm not taking that deal. Let's let it ride, crank the jury up. I'm ready to go to court and go back to jail and sit there. Or I say, you know what? Yeah, I'll do that and move forward. So are those kind of things happening on these non-complex cases? And if so, is it just happening little, or are we doing it in mass?
To a certain extent, those things are happening, but in some cases, we have clients that come to us and say, I want to plead, I want to get out, I need to get home to my family and get back to work. But in most cases, our clients rely on us to use our professional judgment to investigate their case, to see what evidence and what defenses may be out there. Oftentimes, we have to wait many weeks for videotape to be reviewed or other evidence to come back from the GBI. And while it may sound like it's a delay, and it may sound like it's even on our part, our attorneys still have an ethical obligation to investigate their client's case and provide the most
Aggressive,
fully
yeah.
informed information to our clients so that they can make a decision on what they want to do with their case. Now, it may look like we're holding up things and causing a backlog, but what's happening is the attorney is fulfilling his obligation to his client.
Well,
He's using due diligence.
And I want to be clear, it doesn't look like, if that's the process, that's the process. And what that comes back to answer, if we're talking about an overcrowded jail, is if we hear the process is working perfectly and the jail is overcrowded, then the answer is we need a bigger jail. If the cases aren't moving. And we're going through, because I agree with you, if I am someone, I want my attorney, paid or not, to do the steps. But you do have some individuals that you just said that said, hey, look, I want to plea and get out. Well, that stops the process, because even though the attorney is the expert, the attorney's not in charge. The person charged with the crime is the one that makes the ultimate decision. You bring back the plea deal and they say, no, I'm not taking that, and you can't make them take it, so you have to continue moving forward with the case. And so, you know, while I appreciate and I agree that the pay and staffing needs to be improved, I don't think that's the solution to moving the jail. I think there has to be something else out there that we could move a few more cases.
So one of the sticking points is what we call the science. The crime lab reports are not available, and I don't vilify anyone for not wanting to move a case when they don't have the reports. I don't know what the legislators can do to expand the crime lab, but I sure hope that at the end of the day, there'll be a legislation that says if you're just waiting on the crime lab for more than 6 months, then there needs to be a different consideration for the bond. And if that becomes an issue, then we worry about public safety for the most part of it. Then that comes back to us public defenders to make sure that we monitor those who will be coming out, because the legislation out there says there must be a bond or this person must be released because there's not been an opportunity for the district attorney to consider the case or an opportunity for the judge to make a ruling. But the client should not be sitting in jail waiting on signs. And I know that there's a backlog even in that area, and we cannot, it's just what the district attorneys must do. I am not criticizing what they do. I'm just saying to the extent that that is a problem, then we need to consider. And that was one of the, if I have just, what did you call it?
The magic wand.
A magic wand. That was the next one I was going to say. Then there will be legislation that we can put in there to release those people who are just waiting, and the attorneys don't have, we don't have a leeway to make that happen.
So just release them?
No, and that's why I said then the public defenders must come behind
Yeah.
that to make sure that we can monitor those who are released either into a program, an ankle monitor, or a reporting where they report back to us.
So public defenders become probation officers too? Pretrial probation?
We become monitors of our own clients.
By a monitor, probation officer, potato. I mean, I appreciate what you're saying, and I appreciate your passion and compassion. But, you know, to the brass tacks and to what both the senators to my right have talked about, it's the overcrowding in the jail. And while I appreciate programs and the things they work, and I agree that there needs to be more attorneys and there needs to be better pay, it just seems like whether whether you like the jail or not like the jail, the overcrowding problem seems to be coming from outside of the jail as opposed to inside of the jail. And we have to find a way to alleviate that, I think Senator Halpern said, unclog the drain. And so, because we sacrifice public safety on the citizens and victims if we allow, and I'll tell you, the GBIs come to us, the crime labs come to us many times, and their solution to their problem is very similar to yours. More people, more money. Then they said they can move more cases. More labs, they need more scientists, and to have more scientists, they need to pay. Chairman Payne?
Thank you, Mr. Chairman.
Senator,
I had a question. Go ahead.
If I had a magic wand, I think more judges is the biggest solution to the problem. Things happen in front of judges. That's where the rubber meets the road. So I think more judges would help a lot. And Senator Halpern.
And so real quick, you were sitting here, do you agree with the judge's 1.2 formula on how they decide what circuits need judges? I mean, that sounds like a very fair and clean system, doesn't it?
It does.
And Fulton County's coming in at 1.1, or was it 1.17?
Correct.
1.17, so they have determined that judges are not the problem, even though you and I are tracking on they say judges are not the problem. So I just want to say that real quick.
Great minds can differ.
Absolutely.
So, and Senator, one of the things I wanted to add, you asked what were we doing? In Fulton County, we have what's called the Jail Review Committee, and every couple of weeks we try to meet with the District Attorney's Office to see what cases we can move. And sometimes when we meet in January, we may not be able to move a case, but 3 months later when we meet again, the prosecutor may feel that, okay, this person has served enough time in custody, we can do something different. So we're meeting with the District Attorney's Office, and we're trying to make things happen. And one of the big things, every couple of weeks. The other thing too, I think that's a consideration, is the state health department needs to have more beds to get some of the people that are sitting in the Fulton County Jail out that are in need of being stabilized. That's one of the biggest issues we deal with now. We have people who are just caught in the middle.
I think that's a great point. Real quick, I want to get back to Chairman Payne's question.
Thank you, Mr. Chairman. Well, that kind of plays to my question. Does the Public Defender's Office, do you refer your clients to pretrial services before they've had a day in court?
Yes.
I mean, if somebody is obviously, you meet with them, you realize, okay, start the ball rolling. This you kind of go ahead and see this is an obvious setup that the judge is going to order this person to be in some kind of receive mental health services or some kind that you can go ahead and refer before they go to court.
We do make the recommendations, but of course, before anything can really be done in terms of evaluating someone, it takes a court order. And we normally seek and ask for that court order as early as possible, even as early as the first appearance. Our attorneys are trained to, when they interview someone, to just feel how that person sounds and listen for possible mental illness issues. And so as early as possible, we make requests for evaluations.
And follow up on that, as far as accountability courts go, what's the process for, or Public Defender's Office working with those that are already giving the option of going to accountability court, and they're taking that option to go into accountability court, so, for Veterans Court or mental health court? Or
What I'll do is I'm going to have my Deputy Director, Luana Walsh, speak on that, because she deals specifically with the new accountability court.
If you'll slide that mic over to Ms. Walsh, please.
Good morning. My name is Luana Walsh. I'm, as Mr. Kenner said, Deputy Public Defender in Fulton County. So we have, at first appearance, we are working collaboratively with different stakeholders in the Fulton County justice system to identify people as quickly as possible to get them not only into a diversion program, but into some of the accountability courts. So while we may not succeed at getting them into one of the accountability courts until we've done the necessary screening to see whether they qualify, whether they meet the criteria, whether the district attorney at some point will agree to that, at first appearance, we are also just marking those people so that we know to follow up them very soon. We're also making a lot of headway towards trying to work towards pre-arrest diversions, so that those people who look like this is particularly, it's a program that we have established and are working with the Solicitor General on, so that we have at first appearance,
You said pre-arrest diversion.
correct.
Okay.
So it's probably a misnomer because they actually get to the first appearance.
Right.
They're actually
Yeah,
arrested,
my
pre-charged.
pre-arrest version was church, but yeah.
Yes. But we have members from the Policing Alternatives Center who come to first appearance for the solicitor's office, and they identify people who they can divert from being incarcerated right there at first appearance. So those people will never make it onto first appearance calendar. Instead, they are referred to, and this is particularly for the very lowest of low of the misdemeanors. So think, criminal trespass or loitering and prowling, that sort of thing. They have an identifiable need. They are in custody would be in custody only for reasons of poverty. They are in need of services, and so those cases, the Solicitor General and our office work together so that they don't even make it into the jail. So that's one program that has been very effective very recently. We also, our Jail Review Committee is it's a subcommittee of the Justice Policy Board, which is a collaborative effort that includes the City of Atlanta, Fulton County, and members of the state, DBHDD in particular. And we are working towards solutions to getting some reduction in the Fulton County jail system. And so our subcommittee actually compiles a list of cases, and typically they are the non-7 deadly cases. I mean, we're considering the security of the community and taking into consideration what really we can do on cases where there's already a bond set. And again, these are mostly the low-level offenses. All cases are serious, obviously. All felony cases are serious, obviously. But we're reviewing them to see if there are particular criteria that we can establish to divert those cases and review them to see if there's something that we can do. So at our jail review committees, we will meet with Grady Act and say, okay, this person has a mental illness. Can Grady Act take them into the community? Can any of our other providers, so that there's Women on the Rise or some other people who can say they are only in the jail because they cannot afford a bond. They've already got a bond set, so that means a judge has already determined that they're safe for release. And so they are then only being held because, as I said, for poverty, they can't afford a $5,000 bond. And so they are sitting and waiting, and some of our providers, as I said, are helping to get them released and into services as opposed to sitting in jail waiting for that date. We're waiting for indictments. We're waiting for preliminary hearings. We're waiting for, somebody mentioned earlier, once I think it was Senator Albers, that getting them on a calendar perhaps will resolve the issue. Well, what happens a lot of times is that if we have 50 cases on a trial calendar, realistically, we're only going to try 1, maybe 2 cases on the trial calendar. All those other cases remain open cases for us and just have to get reset. So it doesn't really help to resolve those cases.
Do you think one of the possible solutions could be, and the governor's going to sign a bill this Wednesday, that would allow nonprofits to establish bail bond companies under Title 17 and accept the responsibility of that individual if they need to get out of jail, whether it's a complex or non-complex case, in order to prepare their case, thereby alleviating some of the population within the Fulton County Jail?
It is my opinion that those escape hatches, valves, they're tremendously useful because, as I said, a lot of the population of the jail is there only because of poverty. a judge has already established that they're eligible for bond, that they meet the criteria. And again, this does not include all of the 7 deadlies. We're not
Right.
talking about murder, armed robbery, child molestation, none of those. We're talking about people who are being held on $1,000 bonds on a criminal trespass, or a $5,000 bond.
But
on-
engaging nonprofits into the bond system could absolutely
That's-
help with that?
Absolutely. We
Okay.
had been working with one,
Thank
as you
you.
may know. And as I said, they'd offer wraparound services
Right.
to ensure that the person is not just out in the wind. They are offering services, providing, something as simple as letting somebody know when your court date is that you can come back.
Okay.
Because a lot of the failure in people not
That's
coming
true.
back is not because they don't know. They don't have a cell phone that's charged. They may be moving around from place to place.
And in some cases, that's why bail bondsmen who want to get somebody out can't get the person out, because the bail bondsman accepts responsibility for that individual. And if the individual doesn't have a cell phone or doesn't have a way to keep track, the bail bonding companies know that if I get the individual out on the $1,000 or $5,000 bond and I lose track of them, then I'm on the hook for $1,000 or $5,000.
That's correct.
Yeah.
And so, as I said, they have a revolving credit system with some of those nonprofits. And so they want to make sure those people come back. That's the money that they're using again for the next person. And so, as I said, they keep much closer tabs on.
They answer your question? Yeah. All right, thank you, ma'am. Any other questions from the committee? Anything else anyone would like to add?
Just one
Yes, sir.
more comment.
Yes, ma'am.
That I hope this committee is going to go beyond the overcrowding in the jail today. The question is, why do we have this many people in the jail? That is the big elephant in the room. And if we're really going to unclog the drain, then we need to go. This is a manifestation of a bigger problem. What is it that we can do to stop the flow? Because as long as we have the flow, we're going to have overcrowding. Can we just go beyond this if it's in the schools, if it's providing technical skills, if whatever we need to do to foster community safety, as well as making sure that we put our clients on the most progressive path.
And that goes back to her statement earlier where we need pre-arrest
Yes.
prevention, which is the
Absolutely.
community stepping in so that no one is ever arrested. No one commits the crime to begin with, therefore they don't end up in the Fulton County Jail.
And
Right.
if it looks like someone is going down that path, is there a place for us to go? For the parents to go before it actually gets there? Fulton County being the largest, is there going to be maybe a community, this is just a big dream now, you said magic wand. This is one. Can we have a community of social programs that's not only accessible to the people in the criminal justice, but to anyone in Fulton County? So your child is not going to school, you can see the path the child is going, and you can seek help for education and advocacy. Because this is Fulton County, there's an opportunity to do that. We can deal with what's going on in the jail today, and I'm not going to take a long time, but the question is it going to be a revolving problem? What can we do to circle back into the community to make sure that we can reduce the number of people?
Thank you very much. We appreciate y'all coming in today.
Thank you.
Thank you.
Okay, we're going to keep moving. Want to invite up Stephen Kraft, former Chief Assistant Public Defender, retired. Mr. Kraft, if you would introduce yourself, and our question today is the public defender's role in decreasing the overcrowding in the jail.
Okay,
Okay.
just a little bit of a background. Senator Robinson and I share a little common background. I started out as a police officer in Columbus, then became a naval intelligence specialist. I got out and then went to work as an investigator for the old contract public defender system, which many of you may not understand how that worked, but public defenders varied not just from circuit to circuit, but county to county and judge courtroom to courtroom, and how they were appointed and how they got paid and who controlled the purse strings. While I was an investigator, I went to law school, finished, passed the bar, opened a solo practice, and worked both in the state and federal courts, both, and did public defender work in both. In Columbus, we have 2 state courts judges in addition to 7 Superior Court judges, and I did a little work in the state court, and I'm familiar with what the senator said when he talked about on Thursday at the jail, you had jail plea day, and on Friday at the courthouse, you had state court arraignment, and the public defenders and the solicitors had worked together. The solicitors had recommendations for all those cases, and somebody would come in, they'd say, yeah, I want to talk to the public defender. The public defender would ask the essential questions about the nature of the case. Now, most of these these are misdemeanor cases, so the in-depth work that you would see in a felony is not required. Convey the recommendation, go up in front of the judge, stipulate the facts, and the case would move. It's not that easy in Superior Court. Now, in the way of background, the program was created in 2003 under the Indigent Defense Act. It's seen some changes along the way, but it actually came online in 2005, and I was one of the first attorneys in the program and helped recruit some of the attorneys, and I retired last year. It was a tremendous ride. I enjoyed the work, and it's still very important to me that we continue to grow the program. I have handled everything from a jaywalking to 2 death penalty cases. I have outlived a number of judges and DAs and a few police chiefs and a couple of, well, probably about 6 sheriffs now. Columbus is a consolidated government, so we have both the police department and the sheriff's office. The police department's primary law enforcement. Sheriff's office has become more involved in recent years. And to give you an example of one of the complications in all this, we talked about complex cases and non-complex cases. When I first started, like even when I was a police officer, but then when I was first an attorney, most murder cases involved 1 defendant, at most 2. The guy that robbed the liquor store and the guy that drove the car. Now, most murder cases have 4 to 6 co-defendants. And so now you have to have multiple attorneys, and that alone complicates the case. Having said that, in Columbus, because now I've been out of the office for a few months now, so I can't say exact numbers, but I can give you this example. In Columbus, 10% of the jail population are murder cases. That's 2% of the judge's overall criminal caseload. But if you get a docket, you're going to see all these murder cases, and the scheduling orders are going to be for the murder cases. There is no push to bring the minor cases to trial. Now, having said that, because that's the push, the average attorney in my office in Columbus, now Chattahoochee Circuit is 6 counties, Chattahoochee, Marion, Taylor, Talbot, Muskogee, and Harris. Columbus is by far the largest, being the 2nd largest city. We have the most cases. Having said that, we have 7 judges, Superior Court judges. What happens is there's 1 public defender assigned to each of those judges, and they average 400 pending felony cases as we speak. When I retired in June, I had just finished my 3rd murder trial last year. In the first 6 months of the year, 3 murder trials. I had on my desk 14 more murders, along with 300 and something other cases ranging from entering an auto to residue possession of cocaine. So what happens is, in those environments, it's docket driven. DA's indict a case, it gets on the arraignment calendar, the judge puts it on a trial calendar. You are responding to dockets. When you said, if we split it out from 100 cases to 50 cases by adding more attorney, it's still 100 cases. That's true. But now that I only have 50, I am able to look at the low-hanging fruit and say these are non-complex cases and call the DA and say, what can we do about this case? Now, I'm going to give you a little sales pitch that I presented to the Columbus City Council a few years ago. They got some funding for a program, and this is how you attack the backlog. We created what's called the Rapid Resolution Program. We have a dedicated attorney in the public defender's office and an investigator. The DA's office has a dedicated assistant DA, a dedicated investigator, and a dedicated victims advocate representative. When We process people, we handle preliminary hearing. Now, Fulton County is unique. It does not reflect how most of the circuits in the state work, all right? So for the rest of the state, which also has backlogs, Columbus has a tremendous backlog. The city came to us, they got sued in federal court about problems in the preliminary hearing court. And they came to us, they wanted us to help them be part of the settlement, so we gave them a budget proposal, and they gave the funding to hire some attorneys and staff to work just the preliminary hearings. So we contact individuals as soon as they are within 24 hours of their arrest, they have a public defender from our office and an investigator. So we get all the preliminary information, we do that financial qualification, and we get the basic facts for the prelim, where we address hopefully a bond reduction. They have an ADA there as well to look at the case, and a lot of times we're able to come to agreement on bonds at that point. Now, Columbus built a new jail a few years ago. I'm sure you can remember this. They opened the new wing, and it filled up in 6 months. Jail overcrowded. I don't care how much bigger a jail you build, it's going to stay overcrowded because the cases have to be handled in the courtroom. But back to the rapid resolution. At the point when we make first contact with them, we ask them what they want to do about their case and ask for the basic facts. A lot of individuals indicate at that point, yeah, I had the dope in my pocket. Yes, they caught me breaking into the car. Can I just get a deal and plead? As soon as they make that commitment, that case is taken out of the normal cycle and shipped directly to the rapid resolution attorney in our office, who notifies the DA's office, who pulls that from the normal ADA in the office, and they review the criminal history, they review the facts. Now, here's one of the neat things about doing it this way with rapid resolution. They have a victim's advocate, and one of the hang-ups in resolving a lot of cases is victim notification and things like restitution. What happens is they're able to contact the victim right away because they haven't lost contact. Victims change phone numbers just as bad as our clients do, and you can't find them anymore, which delays resolving the case. Because we're now addressing this at the forefront, we are able to get the information. There's a recommendation for, and a lot of the rapid resolution pleas are prison sentences. They're not just confined to probation type cases. We don't do any serious violent felonies there. So now we have a recommendation. The victim's going to get their restitution in the court order. We have a visiting or senior judge come in once every 2 weeks on Wednesday morning, and we have court, and the only thing on the docket are the rapid resolution cases that have an agreement on hand. During COVID, rapid resolution cleared 50% of the closed cases in the criminal division in Muskogee County. On an average year-to-year basis, they closed 25 to 33% of the felony cases in Superior Court. That's with one public defender, one ADA, and a couple support staff, and a part-time judge, because you identify these cases at the forefront and you establish court time, but you have to dedicate the attorney resources to do that. We had to add an attorney because we don't have enough attorneys. As, like I said, 400 caseload, I can't have them doing rapid resolution and their regular cases. So you have to have dedicated resources outside of the normal cycle. Now, magic wand, and not just one thing. You need to pay the public defenders more so that you retain them. Can you imagine 450 pending felony cases and a temperamental judge? You're going to burn these people out. Two, you need more people because that exceeds every national recommended caseload standard in the world. No Superior Court in Georgia attorney should have that many felony cases.
Yes, on that.
What is the average caseload throughout the nation that a public defender should have?
Recommended standard is 175 felony cases. Realistically, a good attorney, an experienced attorney, could handle towards 225. Now, having said that, like I said, I had 14 pending murder cases sitting on my desk. How do I devote the resources to prepare for all of those? And I think that we have to have enough attorneys where those cases can be split out. Now, Fulton has a little few more resources, but for the rest of the state legislature, when you pass the funding for that, do you know how many attorneys are allocated that are paid for by the state in the Chattahoochee Judicial Circuit? 7 Superior Court judges, 6 counties. Anybody want to guess how many attorneys the state funds?
We're not here to guess.
8. And by law, they have to provide 7, 1 per Superior Court judge, and that includes the circuit public defender. Now, we negotiated with the counties in our circuit, and Columbus pays the bulk of the bill. I mean, they pay 80% of the supplemental funding. Columbus funds us an additional $2.5, maybe almost $3 million, and provides 14 more attorneys. Now, mind you, it's great that we've got that, but they fund them at the same pay rate that the state pays, so I can't fill all those slots, because who wants to come be an attorney out of law school for $65,000 a year? Especially carrying the caseloads we have, so it's hard to fill those vacancies. So some counties don't get that kind of supplemental stuff. Some counties get what the state gives you, 1 attorney per Superior Court judge, plus 1 if you have a full-time juvenile court judge, 1 investigator and 1 admin. That's what you find.
That's from the public defender's office.
Yes. Now, all of our attorneys are state employees because we opted to do what's called the spacer. State paid, county reimbursed. We contract with the county for the money. They're all state employees, so they enjoy those benefits, but the county pays for it. So it can be a misnomer sometime about how many state lawyers or county lawyers, and every circuit does that differently as well. But at the end of the day, you have to have more people so they can focus, because you want to move people out of the jail, you got to be able to look at the case and know this case can be moved. If I've got a murder trial set for this Monday and another one set 3 weeks later, I'm glancing at that, see if they got a bond, see if there's any way to get another bond hearing or a bond reduction, and not all judges carry their weight. I'm going to take exception to some of the things y'all heard earlier. And getting a hearing schedule, and then I got to go to that hearing, and there's 20 cases on the docket. I have 2. I have to sit there all day. I can't work on my other cases because I'm spinning my wheels in court on those 2 cases. If we have more attorneys, I can take a baby lawyer, and they can argue a bond motion. I can say, get this on the next bond docket, and get them a bond reduction or get them out of jail, and I can work on the more serious stuff. But the rapid resolution concept is an absolute winner because it identifies those non-complex cases. The DA is the gatekeeper. The ADA that gets the case originally can look at it and say, no, I'm not letting that go to rapid resolution. They're the gatekeeper. But the great thing is, and this is what I told counsel, is it addresses both the defendant's rights to have his case speedily resolved. It addresses the jail population, which saves the county thousands upon thousands of dollars, not just the cost of housing, but medication, because you have so many people who have mental health issues and physical health issues. It allows victims to get closure and get restitution in those type cases sooner and more clearly resolved so that the case is done.
Okay, real quick, Mr. Bright. Now, rapid resolution has been in place for how long?
7 years, maybe.
Okay, and are there numbers showing?
Oh, absolutely. We report
Okay.
those numbers every year in the budget process to the city. The reason that when we presented it as a cost savings. If it costs this much to house somebody in the Muskogee County Jail, and to show you the difference, a rapid resolution case is usually resolved in 60 days. That means they're out of the jail from arrest within 60 days. Non-rapid resolution cases, even the non-complex, just plea it and move it out cases take 9 months.
Wow.
So you can see both the effect on the population itself, but also the effect of cost savings. You could put that money to other uses.
Okay. Any questions related to rapid resolution? All right. Thank you, Mr. Bright. Appreciate you.
All right. I do want to address, if I can.
Yeah, absolutely.
The judge said the chief judge is not in charge. I've worked under 5 different chief judges, and that's simply not true. The chief judge can dictate division of caseloads, of dockets, how the calendar is used.
But wouldn't that depend on circuit to circuit? In his situation, he's in Cobb County and he's familiar with Fulton County. Do you think in some circuits the chief judge has more control over the other judges, whether they yield to him and to follow
I think
his?
the chief judge gets to decide. If you have a multi-county circuit, the chief judge is going to be the one that decides which judge goes to which county.
Okay.
And I
Now,
think,
let's be clear, Fulton is not a multi.
right.
Yeah,
So,
it's a
and
sole.
that's it. But also, the chief judge can dictate that I'm going to have 6 criminal judges, 3 domestic, and 1 civil. However you want to divide that to focus those resources. Now, they said you need more judges. You give me more judges, you have to give me more lawyers, because I can only be in one courtroom and handle one case at the time in front of that judge. So
You're talking about more public defenders.
If every
Yeah.
one of you were a judge and you said, we're going to address those 14 murder cases I have. Well, that's nice that all of you are going to take a case, but guess what? I can't try but one at a time. So that is one of the important things that I think gets glossed over a little bit, why we need more assistant public defenders. It's the caseloads are crushing, and a lot of attorneys like doing the work, but then they get offered a little more money out on the civil side by these private firms with a less caseload. They're like, I love doing this, I want to do this, but here's the money and here's the caseload. So, but by having more attorneys, you can also have more cases ready to go.
And I missed that, thinking that if we add a bench, then we have to add the support that goes with it out of ADA's, out of the DA's office, out of the public defender's office. And when we talk about DA and public defenders, we're talking about DA investigators and public defender investigators also. So it does increase the whole process across the board.
And I know that
Yeah.
y'all have been strong supporters of funding for the public defender, but I just want to give you an example of, we're not just asking for more and more because we're greedy or anything. The district attorney's non-attorney support staff in our circuit is bigger than the entire public defender's office, including attorneys and support staff. They also have the availability of the crime lab, and they can send the police back out to reinvestigate something. I have 6 that office has 6 investigators that can follow up for all the attorneys, and at any given time there is 2,500 plus to 3,000 pending cases in that office between all the counties. So resource is a critical issue in all this. Crime lab needs more because, and I will say this, if I have a client who says, yeah, that was my cocaine and it was in my pocket and he wants to plead guilty, I'm not going to wait and make him wait 6 months for a crime lab. I don't think that due diligence doesn't require that. My client says to me, it was my dope and yes, it was cocaine. If I can get him a probationary plea with some type of follow-up drug treatment and get him out of jail in 2 weeks, why should he sit in jail 6 months waiting for a crime lab? All right, there is due diligence, and then there is covering your butt, if you'll pardon the expression.
Well, let me
but-
follow up one more time. We talked earlier about, you said that the average is 175. A very experienced attorney maybe
That's
could
the
handle-
ABA's recommended
Okay.
standard.
But you said, a very experienced attorney, maybe they can handle 225 at most, and you're talking about caseloads over the average of 400. Is this a one-time, we've got to get it down and clear the backlog, and then it could be managed with the current group? Or is this a systemic problem that not only do we need to get by the backlog, but then we're also going to be ongoing and need more resources? Because sometimes they're different, right?
Right.
Sometimes once we clear backlogs, then we can maintain with the staff that we
Well,
have.
here's the thing, and Randy and I have joked about this before. We could solve a lot of these problems if the police would quit arresting everybody for everything. That's not likely to happen. And in today's environment, there is a focus to make more arrests. I mean, there are no quotas. There were no quotas back when I was an officer, but you were expected to do a certain level of work. And traffic violations lead to minor drug charges. I mean, that's a routine thing. And as a result of that, and the pressure with gangs and guns and criminal activity, there are more They're legal, but I'll call them what they are. They're pretextual traffic stops. That leads to more interaction. More interaction leads to more arrests. So yes, getting the backlog down would change those averages, but without the resources to stay there, those averages would go back up per attorney. I don't think you want to staff it at the level that says 175 per attorney based on the current case flows. If you wanted to come in and say our target is to get it to 250 right now, and you bring in the resources to do that, those resources would, for a sustained period of time, be able to maintain those averages.
All right, I don't want to have to give you a homework assignment necessarily, but I would love to have a follow-up with you for the committee's purposes that said, if the backlog was gone, right, let's say 3-4 years ago, and based on those counts for maybe 2021, 22, 23, now 24, then this would be how much each public defender would have. That would really be able to tell us the true story.
I can tell you that over the last 4 years, the caseload in the public defender's office, not the pending, but the new caseload, has increased by 24%. So.
Yeah, but we don't know what that would be if there was no backlog of how many cases per person.
No, I'm saying that's new cases.
I understand, but right now you can't tell me math with the amount of public defenders you have. If it was just those cases over the last 4 years of how many per attorney that would be.
No, that would take a little finagling.
Exactly.
And I'll say this: one of the problems with all of this goes back to one thing the judge said. The public defender's office has a database system that was created back in 2000 for another agency that wasn't a public defender thing and was kind of modified for that and hasn't really been modified since. And if you want real numbers out of that from reports, you can't get it. I spend hours at budget session time when I'm trying to create that, running multiple reports and manually calculating and counting things because there's no fixed way to count cases.
So what you're saying is that's in the Chattahoochee circuit?
No, we have
or is that statewide?
No, we have a statewide mandated database. It's called JCATS.
Okay.
Every circuit in the state has to use it. There was a plan a few years ago to update that to some extremely modern stuff. We had it down to 2 vendors, and then the then governor decided to pull the bonds for it and use it for to tempt Amazon to come to Atlanta. They didn't, and the bonds never came back. We never got a new database system. The clerk's offices across the state use, in our circuit, among the counties, they use different software systems. And I disagree with one of the things that the judge said about constitutional offices.
Yeah.
You can legislate the database, and you can legislate how cases are counted and who's responsible for reporting them.
Yeah, and we're very aware of that. But
well, let's talk about
Chairman
the
Albers.
the JCAT system. So I sit on Senate Appropriations, and I sit on the subcommittee that oversees that. And I cannot remember in the last 6 or 7 years anybody coming here requesting an update to that system.
No, and I'm going to say that's because the people in the trenches don't get asked what the agency needs.
That's actually not true, sir. I sit here every time and I say, do you have the tools that you need to do your job when they present their budget?
And I think when you say the people in the trenches, you're talking about the ADAs out doing the job.
I'm talking about the people who are representing the individuals, not the agency, not the central office, because the central office is too focused on the metro, and particularly like in these issues with Fulton County, that the circuits are completely different and have very little input into the process. I was on the committee.
But wouldn't an update to JCATS, wouldn't that be beneficial for the state public defender's office?
Absolutely, because
but what I'm saying is because if the people in the trenches, the ADAs down in the courts or public defenders down in the courts, if they had a better system and knew how to manage their cases better, that would make the entire agency
because everything
work.
I do is manually documented in the file. There's some automation that I can put in the system, but But from a management standpoint, as the chief assistant, I had to do a lot of those reporting things. If you ask me how many murders were assigned to attorney so-and-so, judge so-and-so, and how old they were, I'd have to run about 6 different reports and take my legal pad out and manually write all this out. And you can't get an accurate representation of a lot of those factors because the system is just not adequate.
Well, yeah, so that's shame on the agency then for not advocating for what they
Yes.
need. And if we're still operating like we're in the 1990s, then we need to get caught up to the real world.
We do, because JCATS doesn't talk to any other system. It doesn't talk to the clerk's office. It doesn't talk to the jail. It doesn't talk to the DA system. The DA system doesn't talk to the clerk system. Now, there would be limited information that would be shared between those systems, but I bet if you ask the clerks and the judges and the DAs how they actually count a case, what counts as a case, you're going to get different answers. Because in our office, we count individual indictment numbers. The DA's count counts in the indictment. And, you know, I mean, I could, when I was working full-time, I could tell you how many cases the judges were carrying better than they could tell you, because I could figure out how to manipulate the clerk system to get that information out of it.
Seems like a potential recommendation, Mr.
I was
Chairman.
just thinking of that. I think so. And listen, I'm going to reach back out to you. To Chairman Albert's point, having somebody in there that understands where the trenches are, help us. And there is a tendency up here when agencies come in that they are protective in some areas, but upgrades in technology, especially when we're talking about statewide, is extremely expensive. But at the same time, I think in this case, in the criminal justice system especially, it's necessary. So I just want to thank you for coming up. We're going to get our last person of the day up here so I can get everybody home.
And
at a
anybody has
good
any
hour.
follow-up, I'm retired, so it's easy to find me.
I'll make sure, and Allison's going to make sure every committee member has your
And
contact.
if you need anything, I'm more than available.
Thank you so much.
They don't keep any constitutional officers, anything.
Yeah, all right, we're going to shift gears now and ask Paul Morris to come up with Correctional Health Partners. I've asked Mr. Morris to come up and explain the basic process or the basics of corrections health care. In other words, what all components are there, and if someone comes into the jail, what typically available to that person and what they have to go through. We've heard a lot about mental health today, and we know there's issues with physical health, and so we invited Mr. Morris in to discuss the general side of jail health care.
So, Randy, should I tell them anything about
You,
my experience? or-
please do, yes.
So I've been in correctional health care since 1995. I have worked at every level of health care, juvenile health care, women's prisons, men's prisons, county correctional facilities, work release programs. I have published articles in PubMed on mental health care in jails. I've supervised entire systems in New Hampshire, for instance, and Nevada. And one of the things that I'm most proud of is, and Randy was there for this, is I set up the first mental health court in Georgia years back, and that really took off, and it helps us in Muskogee County save, according to the federal government's audit, saved us $4.5 million over the period of 2 years. That expanded into setting up the first veterans dorm in Georgia, and that turned out to be a big success. And then I was noted for having started the first hospice program in a jail in the country. So I'm happy to talk to you. And by the way, I'm not with any company anymore. I'm retired also. So it was a pleasure to have Randy give me a call to talk about healthcare. I'm not sure exactly what the scope of knowledge that you have or what you want. So I have some notes, and I'll try to be brief, and but give you a kind of an overview. So you probably are aware, but forgive me if I bring it up again. Healthcare, prisoners have a right to healthcare, and that right to healthcare is enshrined under the concept of the Eighth Amendment, the prohibition against cruel and unusual punishment. And I've been the expert witness on dozens of cases all over the country on exactly that. people ask, well, what does that entail, the right to health care? Well, it entails essentially the right to a medical judgment, or the right to health care, the right to a professional medical judgment, and a right to whatever that professional medical judgment has deemed to be necessary. And so how you set this up, how you make sure that this happens correctly, is you have to set up a system that really ought to look like a public health system. But it's more than a public health system because everybody's incarcerated, they're all in a tight area. So it becomes something like a hospital and a public health system together. How does a system set itself up? Well, you need to have, first, basic services. You need medical services, a doctor, PAs, nurse practitioners who have prescribing authority. You need to have a mental health system, and probably, in my experience, someplace around 30% of the jail population needs to access mental health programming. Since 1964, when they started to close all the mental health hospitals in the country, except for here in Georgia, and I was fortunate to be the director of nursing at one of them, the folks who were getting mental health programming in hospitals were now on the outside of the hospitals, on the street, and sooner than later were in the jail, where there was no mental health programming. We recognized that years back, and now we provide mental health programming, or should be providing mental health programming in the jails. You need a suicide prevention program. The greatest risk to an inmate, or to someone who's incarcerated when they come into jail in particular, is suicide. They're much more likely to die of suicide than all of the other issues combined, including heart attacks and violence and things like that. So you really need to have a very well-structured suicide prevention program. You need emergency medical intervention. Things happen. Even if you have a good chronic care program, even if you have a good intake, people will have heart attacks, people will have strokes, people will have diabetic emergencies, people will have asthma attacks, and you'll need somebody to respond to those things. Depending on how big the jail is, you can have nurses there around the clock, and you really ought to. Once you have 500 inmates, you really need to have a prescribing authority available around the clock. You need to have an infirmary. Not everyone who gets sick needs to go to the hospital, but they're also not ready to be in the general population. So you'll need to have an infirmary program, and the infirmary has to be supervised by an RN 24 hours a day. A chronic care program. Am I moving too fast, Randy? Yeah, no, not too fast. A chronic care program. So what happens is everything that you see in the community, everything that you may have experienced in your family, diabetes, hypertension, epilepsy, asthma, kidney disease, liver disease, HIV, all of that comes into the jail and needs to be dealt with in the jail. Most of these folks need to be seen at least once every 3 months. But they'll be, speaking about that, the inmate or the patient in correctional facilities, the average number of times that they access a medical services is 18 times a year. Well, that's a significant amount of interaction.
Mr. Morris, real quick, the 18 times, do you attribute that to the population is much sicker, or this is a population that is not normally exposed to such available health care that they tend to take advantage of it? And
Brilliant.
Okay.
That's brilliant. It's actually both. So what happens in the 25 years that I was working with everybody, what happens is people come in and they're very sick. They don't access health care in the community. An example is I had a young man come in, And he sat in front of me and said, 18 years old, he says, I have a perforated ulcer. This is an emergency. He's 18 years old. This is something you generally see in people in their late 50s. Yeah, I have a perforated ulcer. How long have you had this? Since I was 15. Why haven't you taken care of this? Well, I just haven't been to I was planning on it, but my mother didn't get me to the program and so forth. I listened to his stomach. I did my assessment. I checked his vital signs. I was sure he had a perforated ulcer. Sent him to the emergency room as his ulcer was perforating and he was beginning to bleed out. That was his first intervention at 18 years old. That's an idea of how sick people are. By the way, it should be no surprise to you that people come in and a great many of them are addicted to drugs, addicted to particular heroin. These people, the people who are addicted to heroin, also commonly have HIV. Now we're seeing TB. All of these things that are coming into the jail, these folks generally aren't going to get health care in the community. So they're sicker and they're not accessing health care in the community. Health care should be available in the jail or the prison. So it's a good question. Where was I? Dental care. So you need dental care just like you would have it in the community. Everybody needs to see a dentist in the jail at least once a year. Infection control. People come in now with TB and other diseases that we didn't see in the past. We need infection control, and generally we need an infection control nurse. Then there's discharge planning and case management. So a person comes in, they now are accessing all of this health care, and we have them on half a dozen medicines. So they have medicine for hypertension, medicine for HIV, medicine for mental health. They can't just go back into the community with what medicine we send them with, which might be a month's worth of medicine. They have to be linked up with resources in the community, or you can guarantee they're coming right back, which is not cost effective for anybody in the county. I think that's kind of the overview. Do you have questions?
Yep. My thing is, and you're talking about once a year, and the vast majority, as we've heard from the Public Defender's Office and others who have testified this morning, that these individuals typically stay in beyond a year, waiting to go to trial and things of this nature in the complex cases. Do you, I mean, what you've explained, is this a microcosm of the community they come out of, or is this a greater at-risk part of that population that's being housed at the county jails that you're familiar with?
It's a difficult question.
Are we getting a disproportionate amount of sick people into
Yes.
jails?
There's no doubt that the people that come into jail are much sicker than the general community. So, but if you're talking about people who their peer group are other drug users, other heroin addicts and fentanyl addicts, then it's kind of the same thing. But they're am I answering your question?
You are, but beyond addiction issues, are we finding that a higher percentage of jail population are suffering from other
mental illness,
just haven't, obesity, heart ailments, have not treated themselves well? And when you talk about mental health things, is the population in the jail at a higher risk of suicide
Yes.
than the population outside the jail?
So there's a much greater proportion of mental illness inside the jail than outside of the jail. So it's significant. I don't have the statistics, but I can tell you for sure, and that probably 30% of the people in a jail that has 1,000 people in it, 30% of those people are mentally ill. Now, they all don't have schizophrenia. A significant number do. There's an awful lot of folks that have bipolar disease, which tends to cause people to commit crime. And there's a number of people who have behavioral disorders. But 30% of the people that come into jail need to access mental health care. That's not the same in the community. It seems to be growing in the community, but in the community it's someplace around 10 or 12%. So, and access to health, to particularly mental health care in the community had in the past been easier to get to. And now in the jail, at least the jails I've been to, it's easier to get that because you have a screening program, you have people that, you have the medicine available, the medicine brought right to the patient. So we have a larger group of people with mental illness in the jail, a much larger group of people with drug abuse in the jail. About obesity and diabetes and issues of that type, it seems to be about the same statistically. People with hypertension, people in the community have hypertension, people in the jail have hypertension. There's no indication that I know of that people that come to the jail have those diseases more than the people in the community.
Okay.
I have a question. I'm not even
Absolutely.
quite sure what it is. So you just ticked down that in a jail, this is not like prison, but
Right.
in a jail,
Yeah.
county jail, that between mental health services, suicide prevention programs, emergency medical intervention, prescribing, infirmary program, chronic care program, dental care, infectious control, that all of these facets of health care need to be provided for in our jails.
Yes.
And so then, and at the same time, we've got a sicker percentage of people who are in the jails, who are
Yes.
being detained in our jails.
Yep.
So in the best case scenarios that you've seen, or I guess I'm looking for some kind of ratio. Like, this seems like a lot of people that need to be hired to provide these services in a jail.
I'm glad we're on this subject. In addition, all of these people who are sick are in a very tight
Confined.
area.
Yeah.
And they communicate these diseases to each other. And they also add to the overall stress in their cell block and to the officers.
Right.
It becomes a very stressful situation as people's health deteriorates. But please continue.
Well, so I'm thinking about, right, deaths in jail. So you've already said suicide is more likely to be the cause of a death in a jail than any other factor,
Yes.
including heart attacks and anything else. I'm trying to get an understanding then of this kind of ratio between healthcare providers in a jail and then outcomes for the inmates or the people who are being detained in our jails, and
That's going to
what
take
that
that's a brilliant question, and it's going to take a lot of time to actually satisfy you. If we were to just talk, a lot of it has to do with things like the efficiency of the jail itself, how the jail's set up. So if you have a jail that's set up in what you would consider a kind of a wagon wheel, where all of the services are centrally located, it's easy to get people back and forth to the central location. And that's the way we set up a clinic at the Muscogee County Jail, where everybody could come in and out of it pretty easily. If you have a jail like that, you're going to be able to see more people quickly. The older jails, the ones that are particularly stratified, it's difficult to get people back and forth. So what should be happening is some of those services that we're talking about, the nursing services, should be on each floor, which means so that they can see those patients and with the electronic medical records get instructions from the doctor, almost like telemedicine. So a lot of it has to do with how the jail's set up. A lot of it has to do with how the system is set up. For example, In dental, I have supervised a dental program in which my dentist was able to see 8 patients an hour, and never, over probably 10 years, never had a complaint. 8 patients an hour. Most of those patients needed 1 or more teeth pulled. What he would do is he'd bring them all in, they'd do an exam, he'd numb them up, they'd let them sit for a minute while they're numb, he'd come back after doing the x-rays and everything and do the extraction. I went to a place and supervised a state where their dentist saw 2 people a day. And so it wasn't just the amount of providers that you had, it was who was pushing the work and was the system supporting getting that work done, getting people to that dentist or that medical health provider and getting them the resources that they needed efficiently. So efficiency and how things are set up is very important. It's not just the numbers of providers, but numbers of providers are very important too. So if you have 500 patients in a jail, you really need to have at least 1 prescribing authority. Now, that prescribing authority could be a nurse practitioner who they do a very good job. Could be, if it's a physician's assistant, you'll also need to have a physician to oversee that. So if you had 1,000 patients, the physician's assistant is a physician extender and now is going to help you take care of 500 patients while the physician is seeing 500 patients and supervising the physician's assistant. Am I answering your question?
I think so.
In this description, what you're saying would be part of an RFP?
Yes.
Where you would lay it out, and when you put it out for healthcare providers, you put these metrics in there?
Yes.
Saying, based on the population, this is what we require?
That's right. That's correct. So if, you know, and I've written up several RFPs, and what you do is you look at what your historical data tells you, and then you look at how many people are coming into the jail. So I can't remember, but taking Muscogee County, I think they were at one time have about 17,000 people coming in at any one time, resulting in about 55,000 medical contacts. So everybody that comes in needs to be screened. Not all of them are going to stay. Some of them are going to leave right away. But everyone who comes in and gets dressed out to go into a cell, even if they're only staying a day, needs to be screened, because everyone who comes in is at risk of suicide or hypertension or a heart attack or who knows what. I hope I'm answering your question.
Yeah, and can I ask one follow-up
Yes,
thing
but
just
answer
to
any
frame this
question.
out for me? So I think that more typically, maybe the assumption would be that if I am in jail and I am an inmate, the medical care that I'm receiving, once you get screened in, but like, I'm not on like what would be considered a normal well care, preventative care schedule, although you said everybody should at
be.
least see a dentist at least once a year. So is it typical that jails are, and do you know in this state, what the ones you know, is it typical that I am in jail as my time continues to grow, my length of stay continues to grow, that I am on some schedule so that I'm now here for 6 months, you did my intake, now I'm due to be seen again? Or is it really only if I'm having medical problems and complications that I'm really one of the touch points from the medical team?
So it's a great question. So the term typical is the tipping point on that. So what should happen is what you said. So if you come in and I identify a chronic medical need or an acute medical need, you should be on a well care program. You're going to see the doctor in the next, depending on the acute nature of your problem, in the next immediately, the next 24 hours, certainly in the next 72 hours. And then if you're a chronic care patient, you should be seen at least once every 90 days. Does that typically happen? No. But that's what should be happening. And that's what the NCCHC, the ACA, the AJA all understand should be happening. and why that doesn't happen, it does often happen once there's a bad outcome, and somebody then says, you know what, I understand the concept of deliberate indifference, and therefore I'm going to bring a lawsuit. And now we have a lot of attention on that. And of course, there's a lot of money spent on defending that lawsuit and all of that could have been spent, if you don't mind me saying so, on preemptive actions and services, and you'd get a lot better outcome for that, and you'd probably end up saving money.
Chairman Albers?
Following up on Senator Halpern's question, if the process was working properly and people were truly spending 30 or even say 60 days within the jail, that should be a little more spontaneous versus what we have in our prison system, which we know that offender might be in there, inmate might be in there for 1, 10, 20, 50 years, right? That's a whole different challenge and issue. Right. I realize they may be coming in with an acute condition. They might be coming in with mental health problems. I guess my question is if the timing of turning inmates around through the jail was working the way it should be, does it not make sense that those amount of medical things we're dealing with should shrink accordingly?
Yes. For the sake of the patient and for the sake of the institution, I would still set up those programs to see those people, like I've said. But if they are now on their way out, because instead of, for instance, the great benefit of the mental health court that we set up was it took people who were going to be in jail for 9 months before they got into court and put them into the mental health court in 2 weeks and put them into the community with supervision and their medicine, and the vast majority of those people never came back. Is that what we're talking about?
Absolutely, yeah.
All right, so not having the person in jail or in jail for reasons where they shouldn't stay in jail and into the community where they can access services and it's more efficient and cost effective makes a lot of sense. But in a lot of places that just doesn't happen. So you have to have these programs because, and it's particularly much more difficult in a jail like Fulton County or Muskogee County because people are coming and going all the time, and you have to keep track of these people, and they're coming in with illnesses, and you have to deal with that. People who go to prisons have been to jail, and the jail will then stabilize that patient and send that patient to prison with medical records and all of the and all the prison has to do is continue to follow up.
Thank you. No other lights or lit up. Mr. Marshall, I want to thank you
for
your testimony. Committee members, I think today we got a lot more food for thought as we move forward. I think the last 2 upcoming committee hearings are going to get us much further down the road. As I said, the next one will be focusing on finance. And we will have the Fulton County Commission here to discuss the 3 budgets that I think impact our discussion more so. We'll also have the Fulton County Sheriff back to give us a comprehensive update on everything going on within the jail. And then at our final meeting, we will open it and invite any individuals or groups who wish to come in here to be heard on a time system to come in and talk and get the things out front. I think some of the things that are still weighing on our minds are jail deaths. Senator Halpern mentioned it, and I think we understand there's 3 primary: one's suicide, one's homicide, and one's natural. And so I think understanding the healthcare system side of it gives us some ideas of what our jail should be providing for, which is full, comprehensive healthcare system in the jail for those that are addressed, as Senator Albers said, that are there for 30 days. And as with listening to the public defenders in the DA's office, those that are in there for 2 years to make sure that they're getting community standard health care in order to make sure that that's not the reason why individuals are passing away in jail. Any questions, comments? Allison, thank you very much. I want to thank staff for being available today, and this meeting is adjourned.